is a formal meeting and will be held but very much like our normal hearing. We may have technical difficulties. We don't expect any, but if we do, there may be a loss and we may have a short break. And so please bear with us as we go through this. The first item on the docket is first agenda item is docket number 2020-001, cause number 470-01, in the matter of Finley Resources, Inc. This matter has been withdrawn without prejudice. The second agenda item is docket number 2020-007, cause number 602-01, request for agency action of XCL Resources, LLC, for an order pooling all interests, including the compulsory pooling of the interests of certain non-consenting and locatable owners. So we'll take appearances of counsel at this time. Pardon me.
Chairman Gill, Mitch Mayo on behalf of XCL Resources.
And is there anyone representing the division?
Chairman Gill, Gordon Rowe, Assistant Attorney General. I represented the division in the underlying hearing examiner matter.
Okay. And are there any witnesses that need to be sworn at this time?
None for me, Mr. Gill.
Okay, let's go then to the hearing examiner, Mr. John Rogers.
Okay. Thank you, Chairman Gill. Good morning to you and the members of the board. My name is John Rogers with the Division of Oil, Gas, and Mining, and I was appointed by the board to act as a hearing examiner in a request for agency action of XCL Resources, LLC. It's docket number 2020-007, cause number 602-01. It's a request for agency action for order pooling all interests, including the compulsory pooling of all interests in certain non-consenting and unlocatable owners within a 1,280 acre or substantial equivalent drilling unit established for the production of oil and gas and associated hydrocarbons from the Lower Green River, Wasatch, Colton formations. Comprised of first, a drilling unit of Section 14 and 23, Township 2 South, Range 1 West, Uintah County, Utah, and a second drilling unit, Section 30 and 31 of Township 2 South, Range 1 West, Uintah Special Meridian, Duchesne County, Utah. The cause came before me as a hearing examiner on April 14th, 2020. This matter was unique in that all parties presented remotely on their computers, just like we are today because of the COVID-19 pandemic and self-isolation requirements. I'm happy to say the process went very smoothly. Gordon Rowe, Assistant Attorney General, appeared for the division, and Mr. Mitch Mayo represented XCL Resources. XCL had 2 witnesses present. The first drilling unit, located in Township 2 South, Range 1 West, Section 14 and 23, has 1 well proposed and is about 1 mile east of Roosevelt, Utah. The oil and gas underlying drilling unit 14/23 are almost entirely in fee, with a small portion owned by the state of Utah and Uintah County. The majority interests are leased to XCL. As a consequence, approximately 91.20% interest within the 14/23 drilling unit is voluntarily pooled by contract. The second drilling unit, located in Township 2 South, Range 1 West, Section 30 and 31, has 5 wells proposed and is about 3 miles southwest of Roosevelt, Utah. The oil and gas underlying Sections 30 and 31 are almost entirely in fee, with a small portion owned by Duchesne County and a majority of interest leased to XCL. As a consequence, approximately 99.58% of the interest in 30/31 drilling unit is voluntarily pooled by contract. After hearing testimony, it's my judgment that XCL has in both drilling units conducted a diligent investigation to find unlocatables and successor through internet searches of genealogical websites, obtaining affidavits of heirship from known relatives or friends, and probate searches. Also, notice of opportunity to lease or participate in the wells in both drilling units was published in Uinta Basin Standard, Vernal Express, Salt Lake Tribune, and Deseret News. My opinion is that XCL exercised good faith in attempting to find unlocatables and solicit from all non-consenting parties the leasing or participation of their interest in both drilling units. Based on evidence and testimony presented in the hearing, I am recommending that the risk penalty for all subject wells be 100% tangible and 3% intangible risk or non-consent penalty. In conclusion, based on evidence and testimony submitted during the hearing, I, in my role as hearing examiner, find that XCL has proven the need for compulsory pooling of these two drilling units. Therefore, I recommend the board adopt the proposed findings of fact, conclusions of law, and orders submitted in this manner. I'll take any questions at this time.
Okay, board members, any questions at this time? Or Mitch, let's go to the attorneys for a minute. Mr. Mayo or Mr. Rowe, would each of you like to make a opening statement or any comments at this time?
Chairman Mitch Mayo, I don't necessarily need an opening statement. There was one quick thing, point of clarification. I believe John misspoke. He said the hearing examiner hearing was on the 14th of April, but just for the record, it was on Thursday, the 16th of April. One other additional point of clarification that may be new to the board, my client witnesses testified at the hearing as to tangible and intangible costs. Mr. Rogers reflected that in his statements. For the board's sake and to tie it back to the statutes, the 100% is essentially the surface equipment, and the 300% is the drilling costs. And that mirrors the statutes, just as a point of clarification.
Thank you very much. Mr. Rowe?
The division doesn't have an opening statement or any case in chief. We support the proposed order as recommended by the hearing examiner. We worked with Mr. Mayo and counsel for the hearing examiner and would urge you to sign and adopt the proposed order.
Thank you. So we're to the board now. Board members, any questions of board? I'm not seeing any. So I'll take that as a motion from the division. Or would the board member, let's say a board member that would like to make a motion. Please identify yourself in the motion.
This is Mike Brown. This is Mike Brown.
Proceed.
I would make a motion to approve the hearing examiner's recommendation.
Thank you, Mr. Brown. Is there a second to that?
I will second that. This is Susan Davis.
Okay. Any discussion of the motion? The motion before you is to approve the request for agency action as presented by the hearing examiner. We'll now have a roll call vote. Roll call vote.
Yes, Chairman Gill and board members. This is Ms. Julianne Carter here to proceed with a roll call vote. Board members, when I call your name, please respond yay or nay. In alphabetical order, beginning with Mr. Richard Borden. Mr. Borden, how do you vote? Yay or nay?
Yay.
Mr. Michael Brown, how do you vote?
Yay.
Mr. Stephen Church, how do you vote?
Yay.
Ms. Susan Davis, how do you vote?
Yay.
Mr. Ruland Gill, Chairman, how do you vote?
Yay.
Mr. Chris Hansen, Vice Chairman, how do you vote?
Yay.
Mr. Gordon Moon, how do you vote?
Repeat that, please.
Mr. Gordon Moon, how do you vote? Yay or nay?
Julianne, this is Mike Bagley, counsel for the board. Can you hear me?
Yes, I can. Thank you.
I've been in communication with Gordon. He's had some technical difficulties. He's just requested for the board to proceed because there's a quorum.
Thank you. Mr. Chairman, I have 6 affirmative votes.
Let the record show then that that vote was unanimous. And we appreciate all those involved. Thank you very much. And particularly to you, Mr. Rogers, for being the hearing examiner.
Thank you, Chairman Gill.
We'll now go to agenda item number 3, which is docket number 2020
Chairman Gill, this is Mitch Mayo. Can I interrupt quickly?
Yes, please proceed and again, identify yourself.
Yeah, Mitch Mayo on behalf of XCL Resources. I just wanted to thank the board and the division for their efforts. I know that these are crazy times in the oil and gas world, but there is still work that needs to be done, and doing it remotely this way is not anyone's choice. It's not convenient, but it really is important. And on behalf of XCL and mostly on behalf of myself, I really appreciate all the efforts for everyone to get this done in this environment. So I just wanted to leave you with that. Also, I have been instructed that it's preference that I hop off the meeting once we move on to the rulemaking. So unless there's anything else needed from me on the meeting, I will be leaving and watching on YouTube.
Yes, we do have one thing for you. Will you please prepare the order?
I will.
And board members, you should be aware that Mr. Rowe and Mr. Mayo did some excellent work in checking on some technical legal issues and advising the board about that and making sure that they worked with Mike Begley to get the language just exactly correct. Thanks again for all involved. Okay, we'll now go to agenda item number 3, docket number 2020-008, cause number M0370088, in the matter of the Utah Division of Oil, Gas, and Mining's emergency order terminating operations at the Lisbon Valley Copper Mine and requiring reclamation. We'll take appearances of council at this time. Or is this just going to be a briefing?
Chairman Gill, this is Haley Souza representing the division. I have a brief opening statement that I prepared, if now is a good time to proceed with that.
Yes, it would be. Board members, you need to please be aware that when this matter came to my attention was at the very height of the disruptive part of the COVID-19 pandemic, and the division did some heroic work to make this happen, and that is much appreciated. Will be to you, Ms. Souza.
Thank you. So in this matter, the division would like to brief the board regarding an environmental emergency that arose at the Lisbon Valley Copper Mine. Director Baza will provide an overview of the facts and events leading up to the emergency. But before he does that, I'd like to briefly discuss the governing statutes and administrative rules that grant authority to the division to issue emergency orders. Utah Admin Code Rule 641-109-400 states that, quote, the director of the division or any member of the board is authorized to issue an emergency order without notice or hearing. The emergency order will remain in effect no longer than until the next regular meeting of the board. As Director Baza will discuss, the division received a letter from the Lisbon Valley Mining Company in the middle of March, wherein it stated that all operations at the mine had been shut down, that the processing facility was online but was very fragile, and requested the division to immediately step in to prevent contamination to the environment. When the division is notified of a termination of operations, The Utah Mined Land Reclamation Act, Section 40-8-21, Section 3, requires the division to inspect the property and to take, quote, whatever action may be appropriate, end quote, in the furtherance of the act. So based on all the evidence we had available from the mine operator and from BLM staff who was on site, the division acted by issuing an emergency order requiring swift action to address the environmental hazards at the mine. Over the course of the last month, those environmental hazards have been addressed. And because Utah Admin Code Rule 641-109-400 only allows for the emergency order to remain in place until the next regular meeting of the board, yesterday the division issued a division order to the mine operator and to the mine's surety to complete full reclamation no later than September 30, 2021. Yesterday's division order replaces the emergency order and will remain in effect until full reclamation is complete or until a new notice of intention to commence small or large mining operations is issued by the division to a potential new operator. So just to be clear, the emergency order is no longer in effect. The division is not requesting the board, nor is the board required to ratify the emergency order. The division is simply briefing the board on the facts leading up to and following the emergency order. If the board members have any questions now, I'm happy to take them, and otherwise I will turn the time over to Director Baza to brief the board on the facts.
I'm not seeing any hands from the board members. In fact, I can only see 2 of the board members. So we will proceed to Director Baza.
Thank you, Mr. Chairman, and thank you, Haley. This is John Baza, Director for Division of Oil, Gas, and Mining. One quick question. Since this is a briefing, do I need to be sworn as a witness? How does that work?
Just for the record, let's make it easy. John, would you be sworn at this time by the court reporter?
I'd be glad to.
You raise your right hand, please. You do solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Proceed.
Thank you again, Mr. Chairman, members of the board, and I appreciate the Division's counsel for that introduction. I'm going to read some statements that were prepared to do this briefing, and hopefully you'll be able to hear me and see me as I do this. First of all, the Lisbon Valley Mine is a copper mine located in San Juan County, roughly 40 miles southeast of Moab. It operates by placing mined ore on an HDPE liner. And I hope no one asked me what the acronym HDPE stands for, because I don't recall. But they place the mined ore onto this liner where a solution of sulfuric acid is circulated through the ore to dissolve the copper, which is then separated out and collected using electrical processing methods. On March 20th of 2020, the division received a phone call and subsequent letter from the Lisbon Valley Mining Company, the operator, and I'll refer to them as LVMC, stating that it had shut down operations and that all employees were furloughed effective March 18th, 2020, just 2 days before the division got this notice. LVMC stated that some employees had volunteered to continue work to de-energize and shut down the processing facility and to transfer processing solution to storage tanks. Solution in the leach pad was still being recirculated, but volunteers were exhausted, having worked nearly continuously for several days in variable weather conditions. LVMC noted that the weather conditions and the exhaustion of the workers, quote, makes the situation very fragile to retain control of the solution in the leach pad, end quote. The division contacted LVMC's surety, Somco International Insurance, and notified it of the conditions at the mine. Somco elected, or Sompo, I'm sorry, that was Sompo, S-O-M-P-O, elected to take immediate action toward reclamation of the site. That same day, the division issued an emergency order to contain and reclaim any and all facilities at the mine to the extent necessary to immediately prevent any imminent threat of environmental harm or damage. The emergency order further stated that if Sompo failed to take immediate action to ensure the environmental harms were mitigated, the division would undertake emergency actions to forfeit the full amount of the surety bond. The emergency order was issued under the emergency order authority granted to the division in Utah Administrative Code R641-109-400. That rule states that the director of the division or any member of the board is authorized to issue an emergency order without notice or hearing. The emergency order will remain in effect no longer than the next regular meeting of the board. Additionally, the division considered LVMC's letter as a notification of termination of operations, which required the division to cause the inspection to be made of the property and take whatever action may be appropriate under Utah Code Annotated Section 40-8-21, Part 3. On March 27th, which was a week after our initial notification, the division authorized Sompo to expend funds to address immediate environmental concerns, first maintaining existing recirculation, and second, planning for and executing cost-effective evaporation. The division authorized a dollar-for-dollar reduction in liability of the surety for work conducted within this scope, but not a dollar-for-dollar reduction in reclamation liability of the operator. The division required a monthly accounting of funds expended by the surety, which the division has been receiving. On March 31 of 2020, the division reminded LVMC that it considered LVMC's March 20 letter to be notification of termination of operations. The division reminded LVMC that in order for it or any other entity to operate the mine, they must submit and obtain approval of a new notice of intention to commence large mining operations and a new reclamation bond. Beginning April 1st, the division required Sompo and LVMC to submit weekly reporting of expenses, activities to set up enhanced evaporation, water flow levels, pond levels, pH readings, and other items, which the division has been receiving. On April 10th of 2020, the Bureau of Land Management issued an immediate temporary suspension order requiring immediate suspension of all operations. On April 21st of 2020, the division issued a division order replacing the emergency order requiring full reclamation no later than September 21st of 2021. Mr. Chairman and members of the board, that concludes my statements. I'm happy to answer any questions, but I've also asked that Dana Dean, our Deputy Director, and Paul Baker, our Manager of the Minerals Program, be available for any specific questions regarding these activities.
Look, thank you very much. We'll start with Rich Borden.
Hi, this is Rich Borden. A couple of questions just on the nature of the hazard there, of the risks. I assume the leach fluid is an acidic, highly saline metals bearing solution, typical of copper leach operations. Do we have an idea of how much inventory there is? How much water, feet or gallons is there that needs to be contained on site until we're able to evaporate to something more manageable?
And again, Mr. Borden, this is John Baza. I'm going to defer that to an answer from either Dana Dean or Paul Baker. But I would also ask my counsel if we also need to swear in those people as witnesses.
Let's do that. Let's swear in the Dana Dean and Paul Baker. Dana, I cannot see you, so will you represent that you have your hand raised?
Yes.
And that's that, Dana Dean, did you just
Yes,
say that?
I did. I'm trying to turn my video on. But I do have my hand raised, yes.
Okay. Court reporter, proceed.
You do solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
I do.
Okay, which would you like? Who's going to proceed?
I believe Paul has more accurate information on that question.
Paul, identify yourself and proceed.
This is Paul Baker. We understand that there's about 380 million gallons in the leach pad. And your assessment of that is correct, that it would be highly saline and have metals and acidic. Yes.
Another question. John had alluded to using evaporation to reduce that inventory. Is that occurring right now, or do we have sprinkler heads on the leach pads that are spraying water to evaporate it, or what's going on in that respect right now?
This is Paul again. Yes, that is happening. In fact, we have inspectors down there today. I was down there about 2 weeks ago, and the employees were setting up sprinkler lines and sprinklers. The company had those things in inventory that they hadn't used, but they are doing that, yes.
Were they using a drip irrigation system to apply the leach water and minimize evaporation before? Is that how it worked?
That's correct. But they did have other sprinklers that spray it more up into the air. Like say an inventory that they hadn't used. They're trying some other methods as well. They're doing some ponding on the surface of the leach pad. And after some discussions with some people in Nevada, we've recommended that they put some water into some of their ponds, keep that shallow, but the ponds have the black HDPE liner, and we're anticipating that especially during the summer, those can get hot and evaporate a fair amount of water.
Last question, did the operator LVMC, as far as you're aware, make any attempts to reduce the risk posed by processed water release before sending in this March 20th letter? Did they stop imports of makeup water? It sounds like they didn't try to start improving evaporative losses. If you could answer that, that'd be great.
I'm not sure of the answer to that question, but up until the last minute, they were trying to get some funding. And so I'm assuming that they were continuing to operate as normal until March 18th.
Okay, thank you. I'm done.
Thank you. Any other questions of the board members?
Chairman Gill, this is Mike Brown. I have a question, please.
Proceed.
Paul, do you know if they're still receiving lime there for their neutralization process?
It's Paul again. No, I don't believe they've ever received lime. You may be referring to the Tamara mine near
I
Milford.
may be mistaken, but I thought they were to the account of Draymont, Lisbon Valley Copper. I thought we historically supplied lime to them, but I may be mistaken.
I don't know that they have received lime there.
Okay. Thank you, Mr. Chairman. I'm done.
Thank you. Next, any other questions? Seeing none, I'm going to turn the time over to Mike Begley for a point of order on this matter. Is this the matter you wanted to talk about, Mr. Begley?
Thank you, Chairman Gill. It has nothing to do with this matter. It's a technical issue with Susan Davis and communications with her after this matter's over.
Okay, thank you. Seeing any other comments? Again, I just want to thank the division for how they took on this emergency project. I was involved. It was at a very trying time, and it was my first experience with a emergency order. An emergency order of these kinds are not something you see every day, and it was handled very well in my opinion. So back to you, Ms. Souza. That's Ms. Souza.
Thank you, Chairman Gill. And thank you to Paul Baker and Dana Dean and Director Baza for sharing those additional facts. I'd just like to close by once again stating that the environmental or the emergency order that was originally issued was done to prevent the immediate environmental contamination. And since that potential hazard has now been mitigated, the division subsequently issued an additional order yesterday, which is currently in effect, that requires full reclamation of the site. And that division order will remain in effect until that reclamation is complete. And that completes my comments.
Thank you very much. Is there any other comments from the board members? Mr. Borden. Turn your mic on, Mr. Borden, please.
Thank you. I think it might also be worth acknowledging those furloughed workers that voluntarily stayed on site to prevent an imminent release. I think that's very commendable as well.
Okay. Thank you. Appreciate that. Yes, I second that comment. So just to be clear, for the record, there's nothing at this time that the board is required to do other than to be aware of the issue and to recognize that an order yesterday from the division ended the emergency order and put it into a procedural and a process that will make this thing move forward. Is that correct?
That is correct. Thank you.
Okay. Seeing no other hands up or any other indicators if someone wants to speak, we'll close this agenda item. And should we take a break at this time, or should we just motor on? What is the feeling of those presenting and the board members?
Mr. Chairman, this is John Baza. If you would indulge me, I need just a short break before we carry into the next item.
Okay, then we'll take a 10-minute break at this time. We'll come back at about 10:47 to 10:50. Thank you.
Susan, can you hear me?
I can hear you, Mr. Begley.
I can hear you, Mr. Begley.
Ms. Davis, we need a communication channel open, and I can't seem to reach you on your cell phone.
Can't-
Please check
Oh,
that.
sure.
And then just mute your
Go ahead.
phone and then call me, please.
Mute my meeting and call you.
Yes, please.
Got it.
Thank you.
checking that the audio's.
Chairman Gill, I just wanted to let you know that we are ready to proceed when you want.
Thank you very much.
Mics are.
But we're muted right now. Oh.
Yeah.
Why don't we mute him until he's ready then?
Yes, I'm ready.
Okay, we're back on the record. And let's have a roll call of who's here. Julianne, would you call all the names, please, and have them respond so we know whether we have a quorum?
Yes, Mr. Chairman, this is Ms. Julianne Carter here to conduct a roll call. Mr. Ruland Gill, Chairman, are you present?
I am.
Mr. Chris Hansen, Vice Chairman, are you present?
I am.
Mr. Richard Borden, are you present?
I am.
Mr. Michael Brown, are you present?
I am.
Mr. Stephen Church, are you present?
Mr. Church, turn on your microphone, please.
Yes, present.
Ms. Susan Davis, are you present?
Yes.
Mr. Gordon Moon, are you present?
Yes.
Thank you. Mr. Chairman, we have 7 board members.
Thank you all. Thank you, Ms. Carter, and thank you, board members. Okay, we're now on to agenda item number 4, docket number 2017-013, cause number RONG-2017-01, in the matter of informal rulemaking associated with the 2017 and 2018 legislative amendments concerning force pooling and the need to initiate rulemaking on other emerging matters, including but not limited to rulemaking on operatorship designation. Okay, we'll take appearances of council at this time.
Thank you, Chairman Gill. This is Haley Souza for the division.
And any other council present? Seeing none, where do you, Miss Souza?
Thank you. I just want to begin by thanking division staff. They have been working commendably to get through these rulemaking matters. And I just wanted to note that following up on the presentation that Mr. Kessinger made at the February board hearing, the division has continued to work on the operatorship rules and has addressed the issues that arose from there. And so I'd like to call on Director Baza. Director Baza, are you there?
I am here.
Thank you. Will you please provide the board with an update on the compulsory pooling rules?
Yes, and I do have a slide presentation that I'm going to be using. So if you'll give me just a moment, I will attempt to get that up and running.
Director Baza, this is Haley Souza again. Before we move into your slide deck, which is on the operatorship rules, I was hoping you could give the board an update on where we are with the compulsory rules.
Oh, yes, I'm sorry. I mistook what you said. The compulsory pooling rules were presented to the Office of Administrative Rules before the April 15th deadline, before the April 1st deadline, in order to be published in the April 15th bulletin. They were in fact published for a period of time that would conclude a public comment period prior to the May board meeting of the board. So that, I believe, is going to conclude on, if I'm not mistaken, May 22nd. And then the board meeting will occur, at which the board meeting can then be the board's decision-making process to determine whether to adopt the rule as it's been published, including consideration of all the public comment that would have been received during that period, or they can choose to revise the rule and republish it for further consideration, or the board can choose to drop the rule at that time. But at this time on the compulsory pooling, it is out for public comment via the state bulletin, and that comment period will conclude in mid-May, and hopefully the board will be able to consider those comments and make further decisions on what to do with that rule.
Thank you, Director Baza. Do any of the board members have any questions on the compulsory pooling
Ms.
rules and
Souza,
the process?
Ms. Souza, this is Mike Begley, counsel for the board. We're having a technical issue with Chairman Gill. So Chris Hansen, if you're available, could you please step in?
I will, provided I don't run into any more technical difficulties. I'll be here.
Thank you.
Ms. Souza, I'm sorry, I'd interrupt. Technical staff has asked that we pause for 2 minutes.
Okay.
Mr. Hansen, I'm being asked by the technical staff to just give it a little bit more time.
That'll be fine. We'll wait.
Okay, we copy. We see everyone's joining. Thumbs up, hang on.
Highlight speakers.
We can see our chairman and we are ready to proceed.
Thank you, board members. I apologize. I apologize for losing you there for a minute. Can you hear me all right?
I can.
Okay.
Yep.
Good.
Coming in
Thank you.
loud and clear.
Okay, let's go back and Mr. Baza, the last time I think you were talking, what happened in my absence? Did you just take a quick break?
Yes, we did. I was in the midst of talking about the compulsory pooling rule, which has been published in the state bulletin, and the public comment period should conclude by the time the board has to consider these rules at the May board meeting.
Okay. Thank you very much. Appreciate that. So what point are we at, Miss Souza?
Thank you, Chairman Gill. I was just about to ask John, and so I'll do that now. John, I'm sorry, Director Baza, will you please provide?
Myself.
Let's take another pause for a moment while we figure out the technical difficulties.
Oh, up here? Okay.
Are we ready to proceed?
Yes, please proceed.
Thank you. Director Baza, will you please provide the board with an update on the operatorship rules?
Yes, now moving on to the second part of the rulemaking, which was operatorship. I've got a slide presentation that I'm hopefully going to be able to share with the board and get that up and running.
Proceed.
Okay, can the board see the slide presentation?
Yes.
Yes.
Yes, I can see it. Court reporter, can you see it?
Yes, I can see it. Thank you.
Okay, let's proceed.
This was submitted to Ms. Carter yesterday for filing with the board. So this is part of the board's documentation, this slide presentation, but I will walk through it and explain what has occurred with the operatorship rulemaking. As Ms. Souza has indicated, we worked on this diligently since the board last heard a report in February. We've had several online meetings and phone conversations, and we hope that the rule is as close as possible being ready to proceed with it this time. If not 100%, it's probably 95% of the way there and from the division's viewpoint. I'll start off with this title slide just by saying that in all of this, the division and the staff have really tried to address one of our key objectives, and that is how to allow for the highest ultimate recovery from the various fields in Utah, knowing that there's a lot of current technology that's being applied with horizontal drilling and hydraulic fracture stimulation, that it's allowing for more recovery from our fields in Utah than we've seen before. So the rules are designed to help not only allow that technology to be applied appropriately, but to ensure that it's being done responsibly with appropriate attention to the protection of correlative rights. I'll move on to the next slide, and I'll start working through the rules as we've been drafting them up. And hopefully the convention that you'll see is underlined language should be new language that we're adding to the current rules that exist for the areas we're referring to. The first set of rules that we're looking at changing is in the definitions area. And in this, we have several definitions that we're asking for changes on. One is in the phrase application for a permit to drill, deepen, or plug back, or an APD. And I'm not sure why, but we've lacked some definition of APD in the past. So that's something that needs to be put in there just so we know what we're talking about when we're referring to operatorship and the permitting required. So we've got the definition of APD and what that means. The second definition is preparation for drilling, which is a new definition. And what that means is the mobilization of drilling equipment, the erecting of a drilling rig, or diligently engaging in other work necessary to prepare the well site, including but not limited to commencement of access road and pad construction. What that means is that there's a fair amount of capital expenditure involved in all three of those. And once an operator has performed that capital expenditure and the construction that might be necessary for a well site, that is the preparation for drilling. And you'll see further on as to where that applies. Before I move on, is there a question on that? And I'm happy to take questions as we walk through this one by one.
Board members, any questions? Board members, I've written a lot of oil and gas leases that become standard forms and then are used 1,000 times. In the oil and gas lease, there's a term that's called drilling operations. That means that the bit is touching the ground and turning to the right. There are the other definition that the courts have recognized is operations for drilling, which is identical to preparation for drilling as being used here. You're not actually turning the drill bit to the right, but preparation for drilling is set forth as 1, 2, and 3. And as I read Mr. Hunter's letter, I thought there was a bit of confusion on that matter. Since we're not doing drilling operations, we are preparing to drill. Thank you. Back to you, Mr. Baza. I don't see anyone else with their hand up, so we'll back to you, Mr. Baza.
Okay, thank you. I'll move on to the next slide now. This is another definition that we're adding, and it specifically pertains to the language for these operatorship rules. And the definition is that operatorship means the exclusive right, privilege, and duty of exercising any and all rights as granted by the owners or the board to act as operator of a well or drilling unit, which are necessary or convenient for prospecting for, producing, storing, allocating, and distributing oil and gas extracted from a well or a drilling unit, and are delegated to and it shall be exercisable by the operator. Again, we're still in the definition section, and as we walk through this, you'll see where that term of operatorship is being applied. The second bullet on this page is that there was some drafted language on a definition for drilling program and a definition for well. Now, drilling program is a bit of a term of art. It is used in the existing rules, but I think there was a bit of a conflict between the proposal for the definition of a drilling program and how it was being used in the rule. So we removed this definition because the term's used in the current rules, and it would be unwise to create a new definition until we get more precise with how that term is being used in the rules. We also removed the drafted definition for well, because that current term is currently defined in our definitions. And the existing definition is actually more precise than the one that was being proposed. So I'll pause there and see if there's any questions on that.
Board members, any questions on that? Seeing none,
Okay,
we'll go back to you, Mr. Baza.
we'll move ahead to the next slide. This is where we get into meat of what the new rules are actually doing. And this is in section 2 of the rules, and it is section rule number R649-2-4. This is new language, and first bullet says, subject to the provision of subsections 2 and 3 below, the designated operator of a well or drilling unit shall be the owner which, in subpart 1, 1.1, owns outright more than 50% of 1, the working interest in the drilling unit, or 2, in the absence of a board order establishing a drilling unit, more than 50% of the working interest attributable to the leases covering and any unleased oil and gas in the lands upon which the well is to be located. So I'm going to go through all 3 parts of this, but this first part is basically saying one way you can be designated as an operator is you outrightly own more than 50% of the oil and gas interest in that area. So I'll move on to the next slide and just cover all 3 of these. The second part of this, subpart 1.2, says, if said party owns 50% or less of the working interest, having the written authorization and designation by additional owners to operate on their behalf, which in the aggregate with said party's interests total 1, more than 50% of the working interest in the applicable drilling unit, or 2, in the absence of a board order establishing a drilling unit, more than 50% of the working interest attributable to the leases covering and any unleased oil and gas in the lands upon which the well is to be located, or, and the final part is 1.3, if more than 50% of the owners in the drilling unit, or in the absence of a board order establishing a drilling unit, in the leases covering and any unleased oil and gas in the lands upon which the well is to be located, have entered into a JOA, and the designated operator thereunder has non-consented in operation, and the consenting parties have designated another owner to perform said operations, if allowed pursuant to the terms of said JOA, the owner so designated by the consenting parties. So let me recap those 3 parts. So part 1.1 was where there's outrightly ownership of more than 50%. The second part was if you own less than or equal to 50%, you can be designated by other owners who can provide you with the designation, say, yes, you have our appropriate consent to be the operator. And then the third part is if the largest owner of more than 50% non-consents, then through the appropriate JOA, another owner can be designated to perform the operations within that area. So that's kind of a nuance between the 3 parts, but hopefully you can see how they are different and how the rule is trying to address all 3 cases. So before I move on, are there any questions on that?
Yeah, I have a question, Chairman, Director Baza.
Please
Can you
identify
hear me?
yourself. Yeah, just be recognized. So
This is Susan.
Susan Davis. We're gonna now go to Susan Davis.
This is Susan Davis. Yeah, just a question on 1.3. I'm not totally clear what that means. So the majority owner doesn't want to drill. Is that what that's about?
Yes.
Can you clarify 1.3?
as I understand it, and of course, I'm dealing with this from a person who hasn't had a lot of in-depth experience with JOAs, but as I understand the point of this rule is, let's say you are the majority owner. Say you have 55, 60% of the ownership, and you just choose not to consent to the drilling of a well. The other
Okay.
owners who have the minority interest through the JOA that's been established can decide, well, we really think a horizontal well should go forward. And they can then, through the appropriate actions in the JOA, and say, we think that one of us should then be the operator for this new horizontal well. And it would basically be allowed through the joint operating agreement, which is a voluntary agreement that says how those operations are to be dictated on either the lease or on the drilling unit.
So a majority owner in a drilling unit cannot prevent drilling?
Not if the other owners are still wanting to drill it, because that's kind of the crux of conservation law, is that, you know, you don't want to have your right taken away from you. And just because the majority owner doesn't agree with the drilling of a well, if you as a minority interest owner still want something drilled, this is the opportunity to do that. And I hope somebody else would step in and correct me if I'm wrong in the way I'm interpreting that.
Yeah, I'm just going to ask Mike Begley to comment on that. If it's legal to take away the ability of a majority owner to prevent drilling.
Just to be clear, Susan owns the mic at this time until she says
I'm done. I'm done.
Maybe I could answer part of that for you, Susan, if that's okay.
That would be great.
Think of it as there's two ladders on a wall. Ladder number one is the laws, rules, and regulations of the division and the state. The second ladder is a private contract. So what that's saying to me is if more than 50% of the owners in a drilling unit aren't willing to drill the well, we're going to let the contract terms dictate how this thing plays out on the private contract ladder and not use the division ladder. That's how I'm interpreting it. So if you look at the language, it says if more than 50% of the owners in the drilling unit, which means those that would normally be allowed to be designated the operator, in the absence of a board order establishing a drilling unit, so the ladder on that is the division, the rules ladder, let's call it the rules ladder. If that rules ladder is not in place because there's not a board order in the leases covering or in the drilling unit, if they've entered a JOA and the designated operator thereunder has non-consented and operation, and the consenting parties have designated another owner to perform said operations if allowed pursuant to said JOA. So there's provisions in the JOA that allow parties to go non-consent. And how that would work is, let's say that you're the operator and you go non-consent, and I and the other board members who are minority interests want to go forward. We then take over the well and become the operator, but then we hire you because you've got all the equipment and expertise to do the work, but you have no cost in it. The rest of the board members would accept 100% of the cost and risk of that well. All you would be doing it to be a person that would work for us. Does that help explain that at all?
I'm still a little confused about it. Confused is not the right word. Concerned that a majority interest owner cannot prevent drilling going on. Is Mike Begley on? Could he comment on the legality of that?
Susan, can you hear me?
Yes, I can.
Thank you. This is Mike Bagley, counsel for the board. I agree with Chairman Gill's evaluation or summary that there's two somewhat stages contemplated by this language. Although I absolutely agree with you in terms of interpreting this, mouthful is challenging. It seems like there could be some simple grammar or revisions here to make this more clear. However, to your point, and whether it's legal or not, the situation that this contemplates, I believe, is falls within squarely within freedom of contract with the JOA. And so whoever's signed a JOA, this typically, if I understand the language here, is exactly how Chairman Gill kind of contemplated it, is you have the administrative scenario and or scenarios that are contemplated by a JOA. The JOA here would control, if I understand this provision.
Susan, may I respond? You on the mic, but may I respond?
I'm done.
Board members, as you look at this, go to where it says the JOA, and they have entered into a JOA. You could, in essence, interpret the rest of that language as basically saying, we're going to let the private contract rule what happens and not use the board's authority in writing a JOA to override that. I hope that is a way of explaining that makes it a little more clear. And the policy behind it is that something I agree with, is that if the parties can agree, and they've done so by evidence of a JOA, why should the state interact and interrupt that private agreement? Okay, anyone want to comment on that on the board? I am seeing none. Then we're back to you, Mr. Baza.
Chairman Gill, excuse me, this is Mike Brown. I have a different question, if I may.
Please proceed.
Just as a point of clarification, 50% of the owners, are we talking about acreage or the number of owners? So if there were 10 owners, are we talking about 6 owners? Or are we talking about more than 50% of the acreage interest?
It's acreage. So you could have one owner that owns 75% of the acreage, and you could have 5 other owners that own the rest. That first owner would have a 75% voting power with regard to this provision.
Okay, so 1.1 extends to 1.3, or does that somehow need to be clarified? And with that, I'm done.
Okay, thank you. Let me, John, you can take this, or would you let me maybe make a comment?
Well, I just paged back to subpart 1.1, and this is an area where the division had to work through some language, but you'll notice that it talks about working interest in the drilling unit, or if there's no board order that establishes a drilling unit, then it's working interest attributable to leases and any unleased oil and gas. So basically any ownership interest in the oil and gas within that area that the well is going to be encountering. That's where the 50% comes in. Go ahead, Mr. Gill.
So on 1.1, there is no agreement. So there's only one ladder on the wall, which is the regulatory ladder. And that one deals with that situation. Does that make sense there? Okay, I'm seeing Mr. Brown with a thumbs up. Let's go to 1.2. So you're still only in 1.2 deals with a situation where there's not a private agreement and you don't have a majority interest owner. If one of those parties that has acreage less than 50% can get the other acreage owners, working interest owners, to get behind them, then they can move forward again on that one ladder situation of having the state, and they're actually operating under the rules and statutes and of the state. And then 1.3 is the double ladder situation where we're going to say, no, we're not going to have the state rule what's going to happen. We're going to let the private contract control. And hopefully, as I read this, there are no gaps in how this has been written. I wasn't involved in the writing. I've just read it a number of times. And it made sense to me that I can't think of a gap. I can't think of a misinterpretation of it from my perspective, but others may disagree. And so I'm inviting any other board members at this time to speak. I'm done.
Mr. Chairman, this is Mike Brown again.
Yeah,
My
this is Gordon.
question was
Can you hear me
simply
okay?
one of grammar. If you look at 1.3, it's not clear if it's an interest ownership or a numerical ownership. I think there needs to be some clarification language there unless I'm just not reading it correctly.
Okay, so if 1.3 were changed to say if more than 50% of the working interest owners in the drilling unit, so that would not be based on the number of owners. It would be based on it. So I think Mr. Baza and those that are taking notes, if more than 50% of the, insert the word working interest owners in the drilling unit, very well may solve that problem. I'm done, and I ask the rest of the board members to respond to that if they read that differently. And also to you, Mr. Baza, and the council.
I would mention, and maybe Haley can back me up on this, that owner is a defined term already. Let me read you what the definition of owner is. Owner means the person who has the right to drill into and produce from a reservoir and to appropriate the oil and gas that he produces either for himself or for himself and others. So the owner is basically that individual who has the oil and gas title, either by being the owner of an unleased tract or he's leased that property to someone else and granted that right to someone else who is then considered the owner. So I think owner is probably the more general term. We could certainly consider identifying it as a working interest owner, but I think it is probably fine as is from my point of view.
John, I'd like to suggest that since we use the word working interest owner in 1.1 and 1.2, that we use working interest owner in 1.3.
Okay. I'll make that note.
Okay, now, before we move on, let's see if any of the board members disagree with that recommendation. Now I'm done. I'd ask any of the other board members to respond, whether they agree with it or disagree with it.
Mr. Chairman, can you hear me? This is Gordon.
Proceed, Gordon Boone.
John, if you would go to 1.3 again. So at first I was thinking, why do we need that 50% of owners at the beginning there? But if I understand this correctly now, that JOA has to be agreed to by the operator also. It's just that the operator doesn't want to drill the well, and the non-operators do want to drill the well, and so it proceeds. Is that correct? Because at first I was thinking that there was no consent, no joint operating agreement signed by the operator, but apparently there has to be that. Is that correct?
John, can I answer that?
Please do.
Gordon, think of it this way. All under 1.3, all of the players are under contract. They've signed a contract. So you don't have the consent, non-consent triggered under the oil and gas rules of the state. So it's basically saying, we're going to let the contract govern how these people play with each other. Did that answer your question, or is there more confusion still?
Yeah, I guess that makes sense. So I'm just trying to picture the situations where this would apply. So this applies when there has been a joint operating agreement agreed to by the operator and the non-operators, but then at some point the operator says, I don't want to drill this, and then the others can take over under the joint operating agreement.
Yes, and there are different points for this election to go consent or non-consent. It starts out with consenting in the well. Let's say that everyone agrees to drill the well. So you drill it down to the very bottom and you get the test results back. There's another election to run casing. It's called the casing point election. And one party can say, look, I've looked at the data. It's not meeting my standards. I'm going non-consent to run casing. They were consent in drilling the well. They're non-consent in running casing, but all of it is within the terms of the JOA. So the ladder on the well dealing with the private contract is still controlling. So it controls in all instances. And Mr. Balzer, do you agree with that?
Chairman Gill, if I could interrupt, we're having a technical issue with Susan's connection. If I could ask us to pause for 2 minutes. Susan, I'll be calling you on your cell phone if we could stand by for a brief moment.
Okay.
Mike, I'm seeing everything.
Mr. Begley,
We're
you
going
back?
back on.
Sorry, Chairman Gill, we think we resolved our technical issues. Connectivity has been restored. Let me turn the meeting back over to you.
Okay, we're back on the record, and we show that both Susan Davis and Mike Begley are back as part of the hearing. So with that, Mr. Moon, you still own the mic, Mr. Moon.
I'm good. Go ahead.
Okay, you're done. We're back to Mr. Baza. Unless I see any more hands up from the board members. Okay,
Chairman
let's go to Mr. Church.
I still have an issue with related to what Mr. Brown said about 1.3.
Okay, let's go to 1.3.
I'm looking at a case. If we have a fractured interest where owners may only own 0.1%, the numerical number of owners can maybe not total the 51% total net interest in a working interest unit. I feel that the language should somehow or other say that owners who own an aggregate of 51% of the working interest area. Because even working interest owners, if they only have a very, very minor interest, you can get numerically 50% of the owners, but still not have control of 51% of the aggregate area. So there is still an issue I have with the grammar in that 1.3 on defining that 51% of the drilling unit is controlled by the owners that wish to designate another operator.
Okay, so may I respond to this again, Mr. Baza?
Please do.
Okay, let's assume that line 1 of 1.3 has been changed to say if more than 50% of the working interest owners. And let's just take a hypothetical, which is extreme, that there are only 2 parties in the well. One that owns 95% and one that owns 5%. The one that owns 95% elects to go non-consent and notifies the other parties. Then the 5% owner, in effect, takes over the well and becomes the party that is at risk and is the working interest owner that will pay all of the costs. And then under another provision of the JOA, that 5% owner has a choice of either taking physical custody of the well and actually drilling the well, or that party can have the 95% owner drill the well but have no cost in the well or risk in the well. Does that extreme hypothetical explain or designate how this would play out? Mr. Church.
No, I understand that, but what I have a concern is that we're indicating that 51% of the, not just owners, but of the acreage, owners that own the acreage in the whole unit. What if that 5%? Okay,
let me give you a real world situation.
Yes, please do.
In the Brady Field in Wyoming, Exxon was the dominant owner by a large percentage, and the company I worked for at the time is Questar Corporation, owned just a very small percentage. Exxon was not interested in drilling the well, and so it went non-consent on drilling the well, and my company went ahead and drilled the well and found a major field called the Brady Field and benefited from it to a large degree. But the key point, I think, of 1.3 is that in total, the language that is there elects to go under the contract and take the state and the board out of the equation. That's how I'm reading it. So if you've got a private contract, it trumps the regulation of the state. And so that private contract is uniformly referred to as a JOA. I hope I'm telling you, my understanding is I'm not debating maybe your understanding. Do you think I'm missing something? Or Mr. Bozza, would you want to clarify anything on that? I haven't been in the compromise negotiations or discussions, so I'd be interested in your viewpoint on that. And Ms. Souza, if you'd like to also get involved. And Mr. Begley, any of you, three of you would like to comment? Oh, pardon me, can I interrupt a second? Mr. Borden has a question.
So I think I see what Steve is saying. And Steve, would it clarify it for you if you said more than 50% of the working interest in the drilling unit and did away with owners so that people didn't get confused with the number of owners versus the percentage of the working interest?
Yes, I think you're catching what I'm saying. I'm not disagreeing, and I think I understand the concept that Chairman Gill is talking about, that all the owners that have signed the JOA, of course, have already agreed to be governed by that. But it's the grammatical that I would say that if the owners who control more than 50% of the, so instead of 50% of the owners, if owners that control more than 50% of the drilling unit, it's just a very slight grammatical there that I'm talking about. So that the owners controlling more than 50% of the drilling unit, not 50% of the owners. Because 50% of the owners still may not control 51%, over 50% of the area. So it's just a semantics there that I think is confusing.
Okay, let's define a couple of terms then. Let's say that you are, well, Mr. Bozza, I think this is a question for you and for Mr. Begley and Ms. Souza, and that is, if more than 50% of the owners in the drilling unit, that could include people that have signed the JOA, but it possibly can include somebody who is a working interest owner because they have otherwise, it could be a private company that just owns the land outright, like Mr. Moon. In the absence of a board order, okay, then it goes on and it says there's a condition. And Mr. Church, I think you may have a point here. I think you do have a point, pardon me. Have entered into so if you read it to say if more than 50% of the working interest owners have entered into a JOA and the designated operator under the JOA has non-consented to the operation and the consenting parties have designated another owner to perform said operations, if allowed, pursuant to the terms of the JOA, the owner so designated by the consenting parties shall be the operator. Now, that's one way to read that. Anyone else, particularly the lawyers, would you like to chime in on that and see if you're reading it the same way? And by the way, Mr. Church, you still own the mic. And so yes. I'm hoping I'm allowed to have that input.
Yes, I'm concerned that I have not been able to be clear in my concern there. My concern, I think I understand it overall, and I'm in agreement with what this is saying, but I'm just saying that if 50% of the owners who own a net over 50% of the area, that's just that little semantic of about those 4 or 5 words. And I probably haven't made it clear what my concern totally was there, but I can see it can be misinterpreted. Like if you have many owners, but they don't own an aggregate of over 50% of the working interest working interest area.
Okay.
So I'll go ahead and defer back to you just because I've not been able to clarify what my real issue is there.
Okay, the nice thing about where we're at is we still have time to let the parties look at it and see if we can't come to some clarification on that. Any other board members want to comment on that? Ms. Davis? Oh, Mr. Church, are you done?
Yeah, I'm done.
Ms. Davis?
I just wanted to have a general discussion of more than 50%. And the reason I want to have the general discussion is Tony Hunter's letter. Tony Hunter was concerned that this was not a big enough number and that it was easily gamed. I just want John Bozza to comment on that because you've seen a lot of these APDs. I want you to comment on Tony Hunter's concern. Is it valid?
Yeah,
I'm done.
I do want to comment on that, Mr. Chairman.
Please proceed.
Okay, so this was, as you recall, back in February when Thomas Kessinger gave the presentation, the division was still somewhat pressing for a super majority, perhaps 70% or more. And we talked about how that creates some concern about how the 50.1 versus 49.9 was going to be a difficult split in terms of who really is the majority interest owner and how to make that cut. So we had several discussions about this, and the division, after having these discussions, was convinced that 50% was an appropriate threshold for several reasons. First, a lower threshold supports smaller operators who, when they can band together, they may not reach the supermajority of 70%. Let's say they are small companies who, when they band together, can get better than 50%, but would never approach the 70%. Secondly, we feel like it reduces the burden on the board that could result from a higher threshold. Specifically in instances where no one can meet the threshold, a request for agency action would need to be filed by any party desiring to be a designated operator. Because even though we've created some steps here to be designated as operator, if these can't be resolved, I think the bottom line is it would go to the board. A higher threshold might result in the filing of more requests for agency action. And finally, the 50% threshold, even though we said you could cut it finally and say 50.1, 49.9, it was just too close of a call, that would happen at any percentage threshold. If it was 60%, we'd still have the issue of 60.1 versus 59 or 39.9 or 70.1 versus 29.9. We just think that close call will come at any percentage, and that 50% was probably an even enough number and easy enough to discern so that if you got more than half of it, you could be designated as the operator. So does that help answer your question, Ms. Davis?
Yes, it does. I guess the only concern is people certifying that they have 50% that really do not. And that perhaps we need to insert some language about good faith requirements and an affidavit that would have the penalty of perjury if they really don't have that 50%.
Well, I think as we go through the rest of this, you'll find that there is a section as part of the permitting requirement that does ask for an affidavit.
Okay. I will defer until then. Thank you, Mr. Baza. That discussion was very helpful.
Okay.
I'm done.
Thank you. Okay, then we are seeing no other hands or comments. Thank you, Mr. Church, for your comments, and then Susan Davis for yours. We're back to you, Mr. Baza.
Okay, and I just want to recognize that all of this is new language. Some of it we've had to kind of scratch our heads over. And the issue that Mr. Church brought up, I think that's probably one of those things we're going to have to think about and figure out what is adequate language to address that concern. But I will move on. These again are new sections regarding designation of operator. So part 2 says, if the criteria of subsection 1 above cannot be met, or if any owner desires to challenge whether the criteria has been met, or if any owner desires to challenge the designation of the operator on any good faith basis, including but not limited to those additionally specified in R649-3-4 Part 5, and we'll get to that soon, said owner may file a request for agency action seeking board review and designation of a different operator. And then there's some provisions to that. So I'll walk through that very quickly.
Okay, can we just, I just got a note that we need to take a break for just a minute before we get into the discussion of this. We are on a short break.
Mr. Chairman, we've returned. The meeting is yours.
Okay. Before we go back on to subsection 2, if you go back to 1.3, as I've thought about it during the break and talked to my counsel, the intent of 1.3 is to let the little guy play. And I just wanted to make sure that was to let the little guy in. So in essence, it's more favorable to the little guy than it is to the dominant parties. With that, then let's go to number 2, John. And would you mind, since I interrupted you abruptly, could you restart number 2 so everyone's where we need to be?
Sure. And as I mentioned before the break, well, this is John Baza. This entire section of rule language is new. So some of this stuff is, even though the division has had many conversations about it, it might still need some tweaking, but let's work through this. So what subsection 2 says that basically if the requirements or the criteria of the previous section are not met, or if someone wants to challenge that they have to bring that request to the board for review. And I think I'll walk through the rest of the provisions of how that's done, but it gives us some idea as to when that happened. So part 2.1 says, no challenge may be made once the APD for the well has been approved for the protest period, and this is a protest period that's identified in the APD rule. If it elapses, or if the division has determined that good cause exists for waiving the 10-day period. There's also a provision that we'll get to there. I think this is one where we probably need a little bit of discussion from the board, but I would defer that until we get to our 649-3-4, because I think it's going to involve a substantial level of discussion just like we had. But the subsection is basically designed so it clarifies that if preparation for drilling is commenced, but an APD hasn't been approved or the 10-day waiting period hasn't elapsed, a challenge may still be made. In those instances, the preparation for drilling is undertaken at the operator's risk and does not preclude a challenge. And again, that's better specified when we get to our 649-3-4. It also says in these subparts that the board may elect to allow the provisions of an applicable JOA regarding change of operatorship to be utilized in determining which owner shall be the operator, rather than designating an operator under the rule. So as Ruland has mentioned before, that basically defers to the contract that is in place or the JOA. In part 2.3, it says the board may also elect to take the consideration of an operator designation under advisement until it concludes that it has enough relevant information to make an informed decision. So before I move on, we probably ought to have some discussion or Q&A on that.
Okay, Mr. Buzz, are you done?
Yes.
Okay, board members, any questions on this provision? Seeing none.
Roland, I have a question. I was holding up my hand, but clearly you didn't see me. Can you hear me?
Okay, just a second. I'm moving my. Okay, go ahead, Susan. Yeah, I've just had a little difficulty. I can't see you for a moment. Go ahead.
John, this question is for you. What would be the good cause for waiving the 10-day period?
So when we talk about it later, we're not saying we're shortening the 10 days, but maybe it's going to take longer for interest owners to come together and file a protest. They would have to provide some indication as to why they couldn't have protested it within the 10 days. They couldn't get the information. It wasn't readily available to them, as is indicated on the later rule on the division's website. So basically, it doesn't shorten the 10 days. It just says, well, what's the reason for protesting after the 10 days has elapsed? And that was the intent of what we were trying to accomplish, but maybe we haven't made it clear enough.
Thank you. That was helpful. I'm done.
Okay, any other board members want to say something? Okay, seeing none. I kind of like 2.2, which says to me that the board can elect to let the parties continue to negotiate and give them some additional time. But when all else fails, we want to make sure that we have enough relevant information to make an informed decision. So with that, then let's move on to the next section. And by the way, John, I have a word fix for 1.3 that I think may address Mr. Church's concerns. And I think he's hit something, and I think there's a fix to that, but I'll wait till later to do that. Will you go to the next section, please?
Sure. So this is talking about if a request for agency action is filed as provided in previous subsection. This is when someone wants to come to the board and exhibits and testimony are received at the hearing. The board may consider any one or more of the following factors in its deliberations. And this is pretty much a laundry list of what kinds of things the board can rely on to make an informed decision. 3.1 says experience, prudence, and competence as an operator of other wells. 3.2 talks about multi-well expenditures that have already been made for infrastructure. We know that in some cases, these multilaterals or these additional wells, you have to set up the infrastructure to do all of them at the same time. That may come into play. 3.3 talks about good faith negotiations prior to the board's consideration of the operator's designation. 3.4 talks about whether drainage of the spacing or drilling unit has occurred or is likely to occur in the immediate future, and whether an owner has committed to drill a well in a timely fashion. 3.5 is the project complexity and geology. And the division actually added the concept of project complexity because it's maybe not necessarily just complex geology. It could be that there are other issues, reservoir conditions, and maybe enhanced recovery projects that need to be taken into account.
I can't use my mouse over here on this screen. It's over there for sure. Huh? I got to get rid of this.
I'm sorry, I
didn't mute my mic. I've got a, okay, I'm sorry about that, John. I'm back so I can see Susan.
Okay. 3.6 talks about contractual obligations, including those arising under a drilling contract, surface use agreement, or an expiring lease. 3.7 is any other factors the board may deem material to its decision. So again, the previous slide and this slide, we're just trying to iterate what kinds of things the board can consider when it's looking at a protest to the operator designation. I think I'll stop there and pause for any questions.
Okay, board members, any questions?
Chairman Gill, this is Mike Brown.
Okay, Mike Brown, you have the mic.
Mr. Baza, again, Mr. Hunter questioned the whole reason we've mentioned geology in this. Could you just explain for all of us why geology has to do with this discussion?
Well, if an operator wants to be designated as operator, and these are the situations that somebody has actually protested that, let's say the operator is looking at varying zones or varying horizons, that the ownership interest is different than upper horizons. He could actually argue that the horizon that I'm in and the geology that I'm in actually support me being the operator as opposed to someone else. And by the same token, a smaller interest owner may be using that to their advantage, saying, well, the geology here doesn't take into account that I have ownership in a specific horizon or a particular member of a geologic formation that isn't taken into account by the operatorship designation. So that's the reason geology is in there, because just about everything we do in terms of establishing drilling units or other projects are based in what is the geology and how does that support what we're doing.
Thank you, John. Mr. Chair, I yield back the mic.
Okay. I have a question. Pardon me, Susan Davis, please proceed.
John, this is related to Mike's question. Can an owner own only one horizon? I thought you either had the mineral rights or you did not. I'm done.
I'll try to answer that. I think it depends on the conditions of acquired ownership. And I'm aware of certain situations where, somebody obtains that ownership through a contractual condition with the mineral owner, and it only applies to a specific mineral horizon. But that may be the exceptional case, but it can probably happen that way.
That's interesting. I've not heard of that. I'm done again.
We're to Mr. Begley. Would you like to speak, Mr. Begley?
Thank you, Chairman Gill. Susan, to your point, there are instances, and I'm familiar with the Bakken, but I'm not sure how much in Utah, that vertical pew clauses take effect, so that if you're not drilling within a certain time frame, within a certain horizon, that actually could then be released to somebody else.
Thanks. That's very interesting. I appreciate that.
Susan, can I respond to that?
Absolutely.
Okay. Yes, there are a lot of circumstances where you have different ownership to different depths. So think of it as depths. So one is what Mr. Begley mentioned, is between the owner, the operator, pardon me, and the lessee-lessor relationship. There's a clause that you can add to an oil and gas lease that says that during the first, let's say, 3 years, if you haven't drilled deeper, then that lease is then modified automatically to cover only to the depths of which you've drilled. And the other depths below that become now open for, no longer subject to the lease and open for leasing to somebody else. So that is your lessor-lessee relationship. The second relationship is two different working interest owners, where the one can say, I want to drill a well, and the other says, well, I don't. And you say, well, then let me drill the well and earn an interest to the depth I drill. And so on what they call a farm out agreement, that can happen where there is different ownership at different depths. Does that answer your question?
Yes, it does. I'm done.
Okay. Any other questions to Mr. Baza on the 3-point something provisions? I am not seeing any hands, so let's go to Mr. Baza, back to you. I'm done.
Okay, I'm going to proceed into the part 4. And I know this is somewhat controversial too. Subsection 4 contemplates the revocation of existing APDs after a new operator has been designated under these rules. In instances where a unit doesn't have a designated operator, but currently approved APDs exist, those APDs could be revoked under this provision. And this really goes to the concern about the difference between horizontal development and vertical development. And let's say you have some vertical APDs that have already been approved because the division granted those approvals, and there is now a 50% owner contemplates, well, horizontal drilling is really the way to go here. If the provisions of operatorship designation were met, then the concept that we could revoke those vertical APDs would be included in these provisions. And I'll go ahead and read this slide. The operator has a right to request and have the division revoke all other approved APDs for wells for which preparation for drilling has not yet commenced. Other regulatory approvals, license, and operatorship rights in or relating to the drilling unit, or in the absence of a board order establishing the drill unit, in or relating to the lease covering and any unleased oil and gas in the lands upon the well is to be located. Provided, however, that APDs approved pursuant to subsection 364934, that again is the APD rule, may not be so revoked. And I'll stop there for any questions.
Board members, Mr. Borden.
Yes, John, do the APDs currently have a sunset clause if they're granted and then no drilling occurs after a certain amount of time? You remind me.
APD approvals currently by rule are granted for 1 year. Now, I think in our briefing session, we talked about the possibility of allowing for those to extend because of the current economic situation in the oil field. But right now, the way the rule is written, they're granted for a year. They can be extended on a case-by-case basis by application to the division. And in those types of cases, the division has often granted a 1 year extension onto the existing year. But the maximum we've generally allowed APDs to exist is for 2 years.
Thank you, I'm done.
Okay. There's a double-edged sword here. North Dakota and Wyoming do not have a provision in their rules like this, and it has caused absolute pandemonium. I think there was an article about 6 months ago that I sent out that just explained the problems Wyoming is having with all of the members of the Wyoming Commission being brand new and receiving thousands upon thousands of APD requests because their interpretation of their own rules was first come, first served. And so you had people playing games with that. This is to take the North Dakota and the Wyoming problem of gaming the system out of play. Anyone want to comment on that? Seeing none, let's move to the next one.
Okay. That is pretty much the section's new language regarding designation of operator. Because that rule replaces the existing rule 2.2-4 regarding designation of agent, we've moved the language that was previously in designation of agent to a rule called 2-4.5. It basically is a reiteration of the existing designation of agent rule. And it just says that there has to be somebody that is identified as a representative for the operator in all cases for rules and orders and regulatory compliance. So that's what happened here. Even though it's underlined as a new rule, it basically just reiterates what was previously in R 649-2-4. And I'll pause at that point.
So any questions from the board? As I understand it, we're taking a provision that used to be somewhere else and putting it here. Is that correct?
Yes, Mr. Chairman, that's correct.
Okay, I'm seeing no hands from board members. Let's move to the next section.
Now, this is an existing rule, R 649-3-4, which talks about how wells are approved through the permitting process that the division has. And this is where an APD is filed for the purposes of getting drilling approval. The language that we're adding is in this particular section is at the end of part 1. And it says, except as provided in subsections 5, 6, and 12 below, only APDs submitted by the operator shall be accepted and processed by the division. I'll move on to the next section.
Okay, board members, anyone want to comment on that? John, can I ask you a question?
Yes, please.
On that. Isn't that what the Doucette brothers were already doing in terms of how they handled the APDs in the absence of a rule?
Yes, and some of this is clarifying language to try to codify what we've been doing in practice all along, but that is a provision that we had asked for.
Okay, seeing no hands, let's move on to the next slide.
Okay, this modifies part 2 of the rules. Again, it's clarifying language. It says proper identification of the oil and gas lease. Before it just said lease. So we wanted to make sure that was an oil and gas lease. That's what we're talking about here. In part 2.4, this was language to try to help address the way that we're looking at surveys and plats that are provided, and it will also affect how we are recording the well path on a diagram that's submitted to the division, but it modifies the plat or map requirement to say that the well's surface and bottom hole locations in the public land survey system, section township with distances, bearings and coordinates in units, and grid system are then provided. And again, it codifies our current practice, but obviously the rule hadn't been changed for many years, and that's why we have it in place here.
Okay, any questions on that? I'm not seeing any. Okay, let's move to the next slide.
Okay, I'm not sure that we have any significant changes on this. This is basically just explaining that here's an area where drilling program is used, and it didn't seem to comport with the definition that was being submitted to us. So that's why we said that rather than try to include it as a defined term, the drilling program as we have identified it is inclusive of all these subsections. And again, the second slide on that really says the same thing, what's included in a drilling program. And then we've got some clarification. We've underlined the word subsection to say that's additional language. Distance and bearing for the well path is new language. And I'll step on to the next slide. This is the question that Susan, Ms. Davis asked earlier about an affidavit. So this is new language that's being added to the APD that says we require a self-certification evidenced by an affidavit or declaration in conformity with that statutory section from the operator that, and I guess we need to correct some grammar there, that satisfies the criteria set forth in the subsection on designation of operator. And this requires the self-certification to be supported by that declaration in conformity with Utah's Uniform Unsworn Declarations Act. Such a declaration is made under penalty of perjury. So I hope, Susan, that addresses the question that you had earlier.
Thank you, it does. I appreciate that. I do have one more question on the previous section. It seems like everything we have seen when we get matters before us, they include this information. Have you been having trouble getting this information on APDs that don't go to the board?
I would say we don't have trouble generally. I think most prudent operators understand the requirements for a drilling program. It is unfortunately that rare exception where operators who don't quite understand what's expected or don't quite understand what the requirements are in Utah as compared to other states, that's where we don't get the information that we expect. And generally, it's kind of an iterative process where an operator may submit something, but the division says, you know, you're deficient in these areas, you better try again. And that sometimes continues for a long period of time until we get what we want.
I have no objection to these sections. I just was questioning whether we had not been getting them. I think they're good requirements. I'm done.
Thank you. Any other board member want to comment or discuss this? Seeing none, Mr. Bosler, we're back to you. Thank you, Susan.
Okay. This is subsection 3 of the APD rules. It says if the division finds the APD to be complete and otherwise in accordance with the rules of the division and orders of the board, it shall approve the APD. Notice of the approval shall be posted on the division's website in a readily accessible and clearly identifiable format. Now, this was one of the things that we had indicated back in February, that we were somewhat pushing for a notification through a public notice website or through newspaper notice. We've realized since then that the division's website does have the ability to look up APDs. So if a non-operator can see that an APD has been filed, that within that 10-day notice period, they can object to the operatorship designation or the APD, and the division could take that into consideration. But we feel like that we could basically move back on the provision to create any kind of specific notice, and that we would just include that notice as part of the division's website. Now, we will want to improve that with better tools and evolve that website to be more representative of the information that we're working with. But we think that this time it probably meets the minimum requirement to say that someone can look up the APDs that have been filed with the division on our website. So I'll pause there.
Board members, any questions? Yes, Mr. Church.
Just to help me understand, John, so an APD, if it's granted a certain bearing and well path, and you have the planned path submitted and it's posted, when the well is being drilled and the operator determines that they want to revise the well path, and they file a sundry notice with you, does that need to be posted, or how does that work? Is that something that should be addressed here?
I think that's one of the areas where we need to see improvement in the division's data system, because right now I do not believe that sundry notices for changes of plans do go on the website. And if they do, they're in a kind of it's a difficult and tortuous path to find that information. So I think, yes, we need to improve our data management capabilities to show those changes when they occur. Right now, they're just considered by the division and approval is given, but it might be difficult to find that information if you're not the operator of the well.
Okay, thank you, John. I'm done.
May I comment on that just a bit? The division this year filed a request for additional funding for exactly this kind of thing in terms of IT. And the governor approved it in his proposed budget, but for some reason the legislature, as I understand it, didn't fund that. And so that we do have funds for that, but we don't have the aggressive funds to move quickly forward that we thought we were going to get. We thought we had a great case. John, would you comment on that?
Yes, Mr. Chairman, you're absolutely correct. We did make the attempt to include that as part of our appropriation, but it didn't make it through legislative appropriation. So we do have funds that we can use for data management that we will expand in the current fiscal year. Next fiscal year will be very challenging only because, as we know, commodity prices and production will fall back at this point. But we are planning on expending some money on database improvements in the current fiscal year, which ends on June 30th.
Ms. Davis?
I just wanted to go on record and say that I think this is a great effort and needs to be done. Nobody reads the newspapers, is my comment. And to be able to look it up here is by far a better way to notify the public. So I'm glad it's in here. I hope the legislature gives you the money to do it because it's important. I'm done.
Okay, thank you, Susan. Anyone else? Seeing none, John, let's go to the next provision.
Okay, we're moving on to the Part 4 section. And this is where that 10-day waiting period comes into play. And basically, the subsection grants a 10-day waiting period after approval of the APD is posted on the division's website for parties to file a protest challenge. This provision provides an exception to the 10-day period and allows for a party to bring a challenge outside the 10-day period in instances where good cause is shown. This protects the interests of parties where a designated operator fails to take action after an unreasonable amount of time. The provision does not shorten the 10-day waiting period. It only lengthens it. And I think this is an area where we need to have discussion and guidance from the board, because our concern is, as you see by the rule, it says a non-applicant or operator within a drilling unit may then protest the APD approval by filing a request for agency action with the board within 10 calendar days of the posting of the APD approval by the division. But then the highlighted portion says the 10-day period may be waived by the division in its sole discretion on written application and good cause shown. Now, the intent was not to shorten the 10-day period. It was only in cases where we may have to act on something after the 10-day period, maybe days or weeks or months later. It's been commented that perhaps because we asked for the protest to be filed with the board as a request for agency action, that waiver of the 10-day protest period should also be considered by the board and not just a division decision. And again, this is where I think we need some guidance from the board to see what the board's preference would be. We are happy doing those 10-day waivers administratively, but it could be that it would make sense for the board to address it as part of a hearing. So I will pause there and address any questions or concerns by the board.
I have a question, but I'd let the other board members go first. So that my comment has to do with the language in yellow. So while I'm comfortable with that language, and I'm not proposing anything, I'm just asking a question for clarification. If that language says something like the 10-day period may be extended to the next board hearing or waived by the division in its sole discretion, does that improve it at all, John, or is that better to just leave it like it is and get some experience under our belt and then go down that road?
Well, again, this is all new language. It's new practice. We will not have had any experience with this until it actually happens. So it's a case of first impression, and maybe it should be that we have the board do those things and try to identify some logical practice that would make sense.
The next question I have for you is a background question. How vetted was this language with the operators generally and with the operators represented by the Utah Petroleum Association?
Mr. Chairman, I'm going to say that the Utah Petroleum Association has been well included in the division's discussions. I think that they are accepting of this. I think their letter of support that was filed on the public website is indication of that. It has not been well vetted outside of that specific group, the members of the Utah Petroleum Association. And a lot of it came about because we felt we needed to get a rule to the board in draft form as soon as possible. And so some of those other stakeholder conversations didn't happen well.
So it is a provision that allows for discretion and allows for a lot of discretion and additional time. I don't have a problem with it as written. Board members, do you seem to have any concerns about it?
I do, Chairman Gill. This is Susan Davis.
Okay.
I concur with your concern about the yellow highlighted, and rather than just saying waived, which is what we talked about an hour ago, perhaps it should be extended, waived.
That does make sense to me. John, do you want to respond to that? And then after John's response, we're going to take a break for just a few minutes.
Mr. Chairman and Ms. Diaz, I think that is a great modification. I would hope that that is clarifying language, and I would hope that both the members of the Utah Petroleum Association and other operators see it that way.
If they don't, I'm sure we'll hear about it.
Chairman Gill, this is Haley Souza. Can I jump in for a quick minute?
Just a second. Susan, are you done?
Yes, I'm done.
Okay, we're to Haley. Identify yourself, please.
Thank you, Chairman Gill. This is Haley Souza. One consideration with keeping this discretion with the division is that it could potentially add more time to the point when an operator may commence drilling. So in this situation, well, and additionally, it may require additional rulemaking. So I think this causes confusion in what is the division's process for determining whether good cause is shown, and how does an operator go about, or my apologies, a protester, how does a protester go about petitioning the division to make a determination whether they have good cause for making a protest outside the 10-day period. So these rules don't contemplate what sort of process that might take. Additionally, another concern might be that if a protester files with I'm sorry, requests from the division, a determination that they have good cause for filing a protest outside the 10-day window, and the division then determines that good cause has been shown, then the operator or the protester would still be then required to file a request for agency action with the board. And so the amount of time between a resolution of that will be extended depending on when the division makes a determination. I also have questions about how long does the division have to make a determination. So those were some additional concerns that I wanted to make the board aware of with keeping this discretion with the division as opposed to with the board. And I am done. Thank you.
Okay, Mr. Begley.
Director Baza and Ms. Souza, I have a question with the.
Okay, identify
Can you
yourself,
hear?
please.
Yes.
Yes.
My apologies. Mike Begley, counsel for the board. I'm looking at the highlighted language in 649.3-4 that's up currently, and I'm going to draw your attention to the word waived. We have talked about changing that to extended, but are there not circumstances where if we keep the language waived, that the division could receive some information that you'd want a shorter period of time, so that the waived language is meant to not only address potentially extended type circumstances or those situations where that a shorter period of time is merited under the circumstances? I'm done.
Okay, let me ask a question then of both the board and the division. What if this language was modified to say the 10-day period may be extended or waived? So the words would be, and in terms of legislative drafting, isn't it right that the word and also includes or, and the word or also includes and? So the 10-day period may be extended or waived by the division. What does that do to this rule? Anyone want to respond to that?
Mr. Chairman, this is John Baza. I am not familiar enough with the legislative rule drafting requirements to answer that. I would defer to either Mr. Begley or Ms. Sosa to answer that.
Go ahead, either of those two. Mr. Begley, do you want to go?
Yes, thank you, Chairman Gill. You're correct that we went through this process, unfortunately, with the and or conjunctive, but we need to either choose waived and typically or. So to allow the division more flexibility, I believe to address all circumstances, the disjunctive would be appropriate. So waived or extended, but that's just my feedback to what the rules committee likes to see.
It seems to me that if we use the word or, you can have one or the other, and only in rare circumstances could you have both, because there seem to be mutually exclusive, but I haven't looked at the dictionary. What if we said the 10-day period may be extended or waived? Any feedback on anyone on that? Ms. Davis.
I think 10 days, if you just say you can waive it, that means you can do less. And I have a problem with doing less than 10 days. I'm done.
I think we're all just thinking about that for a second. While we're thinking about that, let's have a break, and then we'll come back and talk about it. Okay, we're in a
how much longer are we going to be? When are we taking a lunch hour? I'm getting kind of hungry.
Yeah, I think the break that we're having is just a 3 or 4 minute break if we could, and then we still plan to have a break at around noon. Or should we take that break?
It's 12:37.
It is? I think it's 11:42,
Yes, it is.
but
My iPad says 12:47.
this isn't legal. We need a legal opinion on this.
In Bear Lake, it's 12:37, Mr. Chair.
All right, then I think we're going to take a lunch break. If my computer says 11:42, so
You're on the wrong time zone.
I don't.
Chairman, Chairman Gill, this is Mike Bigley, counsel for the board. The legal advice is this 12:37.
All right. Ladies and gentlemen, thank you for indulging me. I was under the assumption that we were just coming up on noon. Let's take a break. How long would you like to have a break?
Actually, I'd actually like more than an hour. I have to fix my own lunch since nobody made it for me, which is a challenge for me if you know me at all.
All right.
How about we come back at, is 2 o'clock too late for everybody? We could do 1:45.
I'm open for anyone that wants to comment. 1:45 or 2 o'clock?
1:45.
1:45 works for me.
I concede 1:45 is good.
Okay,
We'll have to discuss this with Julie next time.
Okay, we're not going to go to a roll call vote, but we are going to break until 1:45.
Mr. Chairman, we will suspend the meeting till 1:45. Those on YouTube will put down a countdown clock. The audio will be muted during this period.
Thank you very much. Gordon Rowe, do you have something you wanted to say? Okay, we're on a break.
1. Mr. Chairman, the broadcast has been restored.
Thank you. This is the Utah Board of Oil, Gas, and Mining hearing on February the 22nd, 2020. We were last talking about one of the rules, and I think it was John Boz's turn at the mic. John, do you want to make any comments at this time, and then I'll go to the board for additional questions.
All right. Thank you, Mr. Gill. And again, this is John Baza, Director for the division. I'm going to bring up the presentation where we left off. Hopefully you can hear me, and can you see the presentation now?
Yes, I can see it. Thumbs up from several people.
Okay.
Susan, can you see it?
I can. I'm having the same problem with my AirPods that I had before. I'm going through my computer, but the AirPods don't seem to be working.
Let's just take another break. Would you please talk to Paul?
Yes.
Offline here for just a minute, and we'll just take another break. We want everyone to be online. While we're offline, I'd like to ask the court reporter if how this is working for you. Hang on a second. Yes.
Director Baza, I think we are just a minute or two from.
I'm back on.
Okay, excellent. We're just waiting on Chairman Gill at this point.
Let's do that.
Okay,
I'm sorry to step away. Are you back?
I'm back. My Bluetooth is working again.
Okay. So when we last left we're back on the record. When we last left, we were talking about the 10-day period may be waived by the division in its sole discretion. Did anyone have additional thoughts or comments on that? I actually had a comment or two that I'd like to make if no one else raises their hand. Let me give you a hypothetical. Let's say that you own 100% of an oil and gas lease that covers all of a drilling unit. And your lease expires in 2 days. Wouldn't that 10-day period be waived for good cause if no one else is involved? And it could be waived in terms of shortening the time frame? And then I didn't have time to complete it, but in North Dakota, the time is not 10 days, it's only 3 days. And in North Dakota, that 3 days can be shortened for good cause, as I understand it. Is there anyone online that can comment about that? That the language was never intended to be an extension. The 10-day period may be waived by the division in its sole discretion upon written application and good cause. Waiving means it's shortened, as I understand it. Anyone want to comment on that? Yes, Haley, you have the microphone.
Thank you, Chairman Gill. This is Haley Souza. In the discussions with the division that we had surrounding this language, the discussions were always centered around situations where the 10-day period would be extended. Such a situation would be something like an operator had been designated but had not acted for 2 years, and so the remaining owners wanted to come together and have a new operator designated. But the situation that you have just detailed, I had discussions over the break, and while we have been characterizing this as something that would only be extended, it's the scenario you just detailed does seem like it would be for good cause shown. And so while it isn't within the scope of the discussions that we had been previously having, I think that the division can see that there may be situations in which the 10-day period, shortening that 10-day period may be appropriate. And I'm done.
My understanding is that there was this whole language was the result of a compromise between industry and the division, and there were lots of discussions. Can we put this number 4 on hold for a minute and see if we can't get either Haley or Mike talk to the Utah Petroleum Association on the strength of the, what does this, if we were to change it, what would it do to the compromise? What do you think about that, Council?
Chairman Gill, Mike Begley, Counsel for the Board. I would be happy to go on a conference call with Division Counsel and Counsel for UPA during a break and see if there's a way that we can make this or structure this forward.
What I'm concerned about is that if I could come up with a hypothetical, there might be somebody else that can come up with a hypothetical that may not have been mentioned before. So what I'm going to suggest is we kind of table number 4 until we get a little more information so we can make an informed decision. Anyone disagree with that? Raise your hand. Seeing none, John, can we go to the next one?
You bet. Thank you,
Hey,
Mr. Chair.
This is John Baza.
Yeah, John Baza with the Division of Oil, Gas and Mining. Moving on in the section of rules that are being proposed for change. Part 5 talks about the situation where there isn't a JOA and somebody still wants to drill a well. And so let me read the language: in the absence of a JOA, whether voluntarily entered into or imposed by the board pursuant to statute, an owner within the drilling unit may file a request for agency action seeking board approval to drill a well for just cause for which it has proposed, but the operator has refused to file an APD or otherwise drill. If the request for agency action is granted by the board, the division may then approve an APD submitted by the non-operator owner if the division finds the APD to be complete and otherwise in accordance with the rules of the division and orders of the board. Part 6 is really just clarifying language. It says we need to assign it an identifying number, and for whatever reason, that wasn't indicative in previous rules. And then this is where, as we've talked before, there's language that says approval of the APD is valid for a period of 12 months. Are there any questions before I move forward with the next slide?
Board members, any questions? Seeing none, then we are to the next slide.
Okay, part 7 talks about what Mr. Church had asked about before, and it's if a change of location or drilling program is desired, an amended APD shall be filed with the division and its approval obtained. If the APD has already been approved, the requested change should be submitted via sundry, and that probably should say sundry notice, and approved to the division's e-permit system. And that's where I think the division is close to having that data improvement to show sundry notice approvals on our system, but we're not quite there yet, and we need to put the wraps on that.
Okay, let's do two things. Number one, it should say sundry notice. That's how the term is used in our rules, as I understand it. So anyone object to having that amendment done? I think it's appropriate. Okay, now to the substance of that. Anyone have any comments about the substance of 7? Yes, Mr. Hanson.
Just a quick question about the e-permit system. If that's not in place, do we then need to go back and change this text of the rule, or can we put something in there that would cover the division whether the e-permit system gets in place in time? In other words, is there some additional language that we could put in that would allow the division to move forward with this change to the regulations with the anticipation that e-permit system may or may not be in place? Does that make sense?
Yes, Mr. Hanson, and let me clarify that the e-permit system is in place and has been well utilized over the past several years. The only thing that we need to add into that is amendments that are approved by a sundry notice.
Okay, I'm sorry.
Good points.
Clarification.
You done, Mr. Hanson?
Yes, I'm sorry, I'm finished.
Thank you. Okay, seeing no more hands, we're back to you, Mr. Baza.
And part 8 of this section really just says that if the well has been completed or P&A'd, it will not be re-entered until you've submitted a new APD and you've provided evidence of bonding. So that's something we've been doing anyway, but this now codifies it with the language of the rule. And I'll move on to the next slide if there are no other questions.
Okay, does anyone have their hand up? Okay, move on to the next slide then.
Okay. The next slide, there are no changes on this. This is existing language. Talks about an operator who applies for for an APD in areas not subject to a spacing order by the board. Also talks about APDs within areas covered by a proper request for agency action. And it just indicates that APDs in that situation will be held in abeyance until the matter's fully noticed, heard, and determined. And again, there are no changes on that from existing language.
Okay. Thank you. Let's move to the next slide.
Okay, the next slide is, it really just adds some clarifying language. Subsection talks about an APD issued by the division. And then on part 11.2, we've added the language, let's see, that will be terminated unless they are permitted to commence. So very little change there.
Okay, thank you. Let's move to the next slide.
So the next slide is a new rule, and it has the sequence number 3-40. And this was language that was designed to address conflicting operations on overlapping drilling units. And it is 3 parts to this rule. It's not very long, but it's probably necessary to, when we think about the concept that there are drilling units that identify with specific productive horizons that overlap. And so part 1 says, and I'll read it, it is the policy of the board and division to promote the development of all mineral resources on lands under their jurisdiction. Consistent with that policy, operators of overlapping drilling units may enter into a written agreement outlining the timing of drilling and number and locations of wells so as to maximize oil and gas recovery from each drilling unit without waste, minimizing surface impact, and with protection of correlative rights. The reason this is there, again, is to avoid those conflicts, but it's language patterned after the board's authority for multiple mineral development. For example, in the case where you have conflict between oil and gas and mining, there's already rule language that this is adapted to fit the case of overlapping drilling units. Part 2 of this rule says that the division, upon request of either operator, may assist and mediate negotiations to facilitate such an agreement. Then the last part of that rule says, in the event the operators cannot reach agreement, or once having entered into such an agreement, subsequently disagree on the application of the terms and provisions thereof, either operator may file a request for agency action with the board for an order seeking delineation of the respective rights and obligations of operators as to each drilling unit overlapping, including the timing, number, and location of authorized wells to effectively carry out the stated policy. So all 3 parts of this new rule are designed to preserve the voluntary agreement that can occur between operators, but it also provides some actions and protocols if voluntary agreement cannot be obtained. And I'll take any questions or comments on this or any other part of the rules that we've talked about.
Okay, board members, let's start with talking about this part of it. Any questions about this part? Seeing none, John, I have a question.
Sure.
In a lot of the long lateral horizontal requests for drilling units, the request is for wine rack like spacing of the wells within the formations. But yet when we get to the drilling unit boundary wells, almost by definition, they have to be stacked, one above the other. would this allow those operators to come to either come to an agreement among themselves, or to come and have you facilitate a discussion about having a wine rack kind of drilling unit that, pardon me, a wine rack type drilling unit boundary drilling unit that could cover those operations? Because it comes down to the fact that if there is such a boundary unit, the production is shared pretty much 50-50 on both sides. And I can see many circumstances where the operators could say, even though that well that would have been stacked, if we do a wine rack, we'll still share that one 50-50 on our land if you'll share the next one that is 50-50 on your land. Am I understanding that correctly?
If I can paraphrase what you said, and maybe so for my own understanding, you are concerned about the drilling unit boundary, where there might be, for example, drilling unit boundary wells and multiple drilling unit boundary wells, because that is the configuration that would have to be put in. Is that what I understand you to say?
Yes, pretty much.
Okay. Well, I think it goes back to the part one, where we talk about, consistent with that policy, operators of overlapping drilling units may enter into a written agreement. I certainly wouldn't construe overlapping to automatically apply to boundary unit or drilling unit boundary wells. So maybe we need to adjust that language somewhat, because I think the idea of allowing the operators to enter into voluntary agreements is a good one. And if we can allow it on drilling unit boundary wells, as well as overlapping drilling units, so much the better.
So much the better. Okay, I'm done. Anyone else want to comment? Okay, so then we're back to, from this slide, to comments on all of the slides. John, could we go back to the very first set of where we have the slides where we had 1.3? And I just wrote this down.
I believe this is the slide you're referring to, Mr. Gill.
Yes, and this is also back to Mr. Church's comments. And I'm asking the scriveners here to help me put this down. What if it said this? If owners, let me make sure it's clear. If owners, with a capital O, owning more than 50% of the working interest, and then it would start again with the existing language in the drilling unit. So let me repeat that, and I'll read the first two lines as they would be amended. If owners owning more than 50% of the working interests in the drilling unit, or in the absence of a board order. Okay, do you understand what I'm saying there? Okay, may I ask Mr. Church to see if two things, Steve. Number one, do you feel that answers your question? And number two, do you feel like your question was understood enough that is a solution?
Yes, that answers my question. I think it clarifies it for me, and hopefully for future usage of this.
Okay. Thank you very much. And then, so the next amendment that we were talking about was the deletion of the word is. And I can't remember where that exactly was. It was just a superfluous extra word. John, do you remember where that is? or Julianne or anyone else that's been keeping track of possible amendments?
I'm looking for it. I remember when we mentioned it during the presentation, but I'm not putting my finger on it right away.
Chairman Gill, this is Mike Bagley, counsel for the board. I was unfortunately doing something else at that time, so I can't help you on where that's located.
Okay. Well, there was the word that doesn't change the meaning. It was just a superfluous word. And then the next one was an amendment to change sundry to sundry notice, which I thought was inconsequential. And then there was a discussion of section 4 that we tabled. John, could you get that back up?
Certainly.
Chairman Gill, this is Haley Souza.
Yes.
That grammatical error is on page 7 or slide 17. It's on part 2.7.
John, can you take us back to that, and we'll wait.
Okay, I think I've got there.
Okay,
Yeah.
so we're on 2.7. We're on the third line of the slide. The third line currently reads, et sec from the operator, that is satisfies the criteria. The word is on that line would be removed, so it would read et sec from the operator that satisfies the criteria. Does everyone understand that amendment?
This is Haley Souza. I would propose changing is to it.
Either way. That. Okay, so that it satisfies. It or ITS?
IT.
Okay, so it satisfies. So it's a typo, not an extra word.
I believe so.
Okay, by doing what we just did, does everyone understand what we're doing? Let me read it again. Et sec from the operator that it satisfies the criteria set forth. Anyone have a problem with that? Are we clear? Okay.
No, it's not clear what it means. I thought it was much better to just take it out, which is what we had talked about earlier. Is it the self-certification or is it the operator?
It is the operator. But if we take it out, then that would also work because then it's talking about the self-certification.
Well, we just said from the operator that satisfies. I don't care.
I don't care
Either
either.
way.
No, this is Chris Hansen. I believe taking the word out completely makes that a more clear reading of the regulation. Because what you're referring back to is the self-certification from the operator that satisfies the criteria set forth in subsection 649.
So could you read?
I agree with Chris.
So let me make sure everyone's clear. Let me take out the middle language. A self-certification that satisfies the criteria set forth in subsection X. Does everyone read it the same way?
Yes.
Then let's take that word out. If you feel strongly about it, speak up. Seeing none? Okay, then we are, oh, no, I got a couple of hands up. Mike Begley.
I just have another cross-reference error above. So if someone has some substantive comment to your last question, they should go first.
I saw none, so you've got the mic.
Okay, if you wouldn't mind, Chairman Gill, or John Baza to go to sub 1 of that same rule, 649.3-4. It's come to my attention there's cross-reference because there's been amendments. So the last line of sub 1, the internal cross-referencing should be subsections 4 as opposed to 5, 5 as opposed to 6, and 11 as opposed to 12. So it should read subsections 4, 5, and 11 below.
Anyone be accurate? So that sounds good. Are you done, Mr. Begley?
I'm done. Sorry about that, Chairman
Thank
Gill.
you. Okay. The Scriveners, do you believe you have that? Okay. Were there any other amendments that we failed to mention? Yes, Mr. Begley.
I'm sorry, Chairman Gill. I didn't know you were going back, but I think we should at least, if we're doing this now, go back and do it to R649-2-4. I'm sorry, Director Baza, I'm not sure what slide that's in, but that's the designation of operator rule. And if we could go to the last subsection 4, I believe that preparation for drill, which is the second line that I have, or preparation for drilling, excuse me, that actually is a defined term. So it should be initial cap P, initial cap D.
Hi, this is Natasha. I have a comment about capitalizations. They will not, they as in Office of Administrative Rules, even if it's a defined term, they say it shouldn't be capitalized. So that's why it's not capitalized in there.
I defer to Natasha on almost everything, and certainly this.
Well, then there are a number of places where there is capitalization. For example, owner.
Yeah, so
And-
I've actually, in the copy that I have, I don't have any of them capitalized. So
Okay.
we
Well-
should be good, but I'll continue to go over and make sure
All
we
right,
don't
well-
have capitalizations.
Well, just as a matter of practice, unless the board approves the change in that capitalization or is aware that it's going to be done in the normal course of business, it should not be done.
All right.
So, board members, the proposal before you is that Natasha is going to go through this proposed rule where a defined term starts with a capital letter, that'll be changed to conform with them. Who was them or they?
The Office of Administrative Rules.
Okay, and that's the kind of the legislative format that they use for interpreting rules, is that correct?
Yes. Yep.
Does anyone have a different opinion about that? Okay, Mr. Hanson.
I just have a question about the correction we made concerning the question that Mr. Church raised when we changed that text from, I think we have two owner words, one following the other. And I'm wondering if that will lead to some confusion if one is not capitalized. Do you remember, Mr. Baza, which section that was in?
Yes. I think it was here.
And Mr. Chairman, if you could read again what your suggested text change was?
Mr. Hanson, Chris, you nailed it. And so we've got to look at that. I got to go back and find my note here. Hang on a second. If owners, capital O owners, owning more than 50% of the working interest. So it is owner owning.
I guess.
I liked it there personally, but so if owners, capital O, owning more than 50% of the working interest. For clarity, should we leave that O big capitalized?
I guess in my, as I imagine it in my mind, reading it, maybe not having the capitalization is not as big a deal as I initially thought. So I'm good either way. And I'm
Okay,
done.
but it was a good question and thank you. Any other places, Mr. Begley, that you suggest we have cross-reference corrections, or Natasha, that we have capitalization issues that you already know about? We'll start with Mr. Begley.
Chairman Gill, if we could just then go to where our last revision is, or it's almost the last, where there was the discussion of what it should be in terms of it, or whether, so it's 2.7 of 649.3-4.
Okay.
I believe the intent, the drafter of this rule has informed me that it refers to the operator. And it should be it, not is. And that was a typo. So
From the operator that it, the operator, satisfies the criteria.
Correct.
Okay, then can I recommend to the board that it should be it, if it's referring to the operator, and let the dialogue and the record show that that's what we're intending it to mean, is that it is that the operator satisfies the criteria. Actually, that's an improvement. Any comments on that? So, seeing none, let's put in the word it. So that line reads et sec from the operator that it. Do we want to replace it so that there's no question about it? So it says from the operator that the operator satisfies the criteria. And then there can be no confusion. Thoughts? Okay, let's try this then. Mr. Hanson.
I believe that would satisfy any confusion that would be that would come forth in the future, whether it was referring to the operator or the previous statement. So I would suggest accepting your language.
Okay, Ms. Souza.
I might suggest, for additional clarity, if we want to take that route, that we move the first from the operator up to the first part of the sentence. So it says, a self-certification from the operator, evidenced by an affidavit or declaration in conformity with this section, that the operator satisfies the criteria set forth. So we don't have the operator, one word, the operator.
I can agree with that. Board members, anybody have a problem with that? That's an improvement. Okay, are we clear on that? So as I understand what's being recommended, it would read that section 2.7 would read somewhat as follows. A self-certification from the operator, evidenced by an affidavit or declaration in conformity with section 78B 18A-101 at SEC, that the operator satisfies the criteria set forth in that subsection. Is everyone clear on that? Okay. The next one. Let's move to the next possible amendment or cross-reference clarification. Thank you, Ms. Souza. Okay, do we have any more, Mr. Begley?
I believe we've moved beyond this, and this would be the same rule that we were just on, subsection 7, the addition to notice in sundry notice.
Okay. Where did we make that, Vice? Okay, we're on section 7. Okay, just so that everyone's clear, we're at 649-3-4 subsection 7. And the line would read, as it currently reads, if the requested change should be submitted via sundry, and the change would be the requested change should be submitted via sundry notice. And is everyone clear what we're doing? Seeing no comments. Okay, let's go to the next one.
Chairman Gill, this is Mike Bagley, counsel for the board. I don't have anything further to add. I think it's back to Director Baza.
Okay, Director Baza, we tabled one issue. Can we go back to that? It was subsection 4. And the last time we discussed this, there was a request by council to talk to operators or the Utah Petroleum Association or both about what was intended by this language and what was its importance in the overall compromise language. Has that occurred?
Chairman Gill, counsel for the board, it has not occurred as of yet.
Do we have another matter after this? Would it be worthwhile to take a short break and see if we can cause that to happen?
Chairman Gill, I think there should be at least 10 days.
Well, here's
This is Susan Davis.
Okay.
I heard your your example. I think 10 days, people need a chance to digest and respond.
Would it be okay if I repeated back my understanding of what you just said?
Sure.
What I understand it would be that the yellow language, the 10-day period may be waived by the division in its sole discretion, would be left as is so that two things happen. Number one is that a person that would like to object or oppose has a 10-day period. But that 10-day period could not be extended, and that it could, on a showing of written application and for good cause shown, could be shortened. Is that what I'm hearing you say?
No, the opposite. That the 10-day period could be extended but not shortened.
Okay, so does everybody understand what's being said there? Mr. Hanson.
This is Chris Hansen. I understand what's being said, but if we leave it as is, may be waived, it can go either direction, couldn't it? It could be shortened or lengthened based on a written application and good cause shown. I'm done.
Thank you. Ms. Davis, do you want to reply to that, or Mr. Borden?
Go ahead, Mr. Borden.
Mr. Borden, you have the mic.
Thanks. This is Rich Borden. I agree with Chris. It waived to be made longer or shorter. If you wanted to be explicit, you could say extended or reduced or something similar to that. And Susan, I realize you don't want to be
Let me interrupt you for a second.
Sure.
The court reporter has something to say.
Mr. Borden, can I get you to repeat and speak right into your mic? You cut out quite a bit.
Oh, my apologies. Can you hear me now?
Yeah, much better. Right into that mic.
Okay, so it's my understanding, I agreed with Chris, that waived could imply either extending or reducing the 10-day period. If you wanted to make that explicit, you could say extended or reduced or similar words. I would also add, I know there's concerns about reducing it, but does the with good cause shown or good cause shown alleviate those concerns at all? There would have to be some valid justification to reduce the 10-day period, which is your starting point. Thank you.
Okay, you're done. Who wants to speak next? Let me,
I would like it to just say extended, not waived.
okay. And let me ask you guys that work for the big companies, would your company spend a lot of capital under a rule where you could begin spending a lot and find out that an open period of protest is still ongoing? Mr. Hanson.
Could you clarify that a little bit more? I think I know what you're saying, but could you say that a different way so I'm sure I understand? And I'm done.
Thank you. What I'm going to say is, with all due respect, I think I disagree with Ms. Davis, and in this respect, I don't think that using the word extended tells everyone the rules of the game. I know that if I was in a big deal and I knew that there was an open-ended period for extension, I would have a real problem starting the capital expenditure. So as far as my looking at this, I would not extend the 10-day period. North Dakota only has a 3-day period, and that's not, to my knowledge, extendable. It can be, but I don't know North Dakota law. What I would like to suggest is that the 10-day period be what Susan asked for, but that the word waived would be shortened in its sole discretion. And so that's what just in fairness to both sides, I want to, and what I'm saying is, and let me say it a different way. What I'm saying is you have a fairness to the people that want to protest, but using the word extending it, I think, is unfair to the other side. And so 10 days is fair to complain. I see you, Gordon. And but I think it needs to work that way. So we'll start with Gordon Moon, and then we'll go to Mr. Brown. I'm done. Mr. Moon.
Yeah, could I? Yes, thank you. Could I have John Baza and Miss Sosa just explain again the genesis of this change in yellow? Thank you. I'm done.
I guess, and this is John Baza. I'm the one who highlighted that, and the 10-day period, as we understood it, it was to allow, let's say, an operator who had not acted on an APD and it had been weeks, perhaps months after the approval, and they had not proceeded with preparation for drilling. It was my understanding from the division standpoint that waiving the 10-day period would then allow somebody farther on down the road to protest the operatorship for whatever reason. And there's those reasons defined earlier in the rules. But we did not construe that initially to say that the 10-day protest period would be shortened at all, but that it could be lengthened based on the inability or inaction of an operator to conduct preparation for drilling. And I'll let Ms. Sosa comment some more on that. If she cares to.
Thank you, John. This is Haley Souza. I'll just echo what John said, but I do also want to acknowledge that I came into this at the very end, and so there may have been discussions where this was, where this was discussed as being shortened. I think the scenario that Chairman Gill has come up with, where a lease is expiring, could potentially qualify as good cause. And so I suspect that the representatives from UPA also anticipated that this period could be shortened, but because I came in at the very end of this tail end, I can't speak to the entire process.
Haley, you done?
I'm done, thank you.
Okay, we'll turn to Mr. Brown.
I was just wondering if the word adjusted might be a better word than any we have suggested. And I yield back.
Okay. Mr. Moon?
I would agree with Mike. I think, and also Rich, the good cause requirement, I think creates some safety on both sides. And, I don't think it's going to happen very often for it to be shortened or lengthened, but I think the 10 days ought to be what happens most of the time. But if there's good cause, there could be an adjustment there. I'm finished. Thanks.
Okay, Mr. Begley?
I have a question directed towards the division based on Ms. Davis's concern or suggestion that it's only extended. It seems to me if there's only an extension and a good cause requirement, how far will that go in terms of the issue needs to be resolved somehow, some way? In other words, it would seem to me that if there's an issue with a protest, that it would want to be resolved, or the division would want to try to resolve that and potentially bring something before the board and have this issue dealt with expeditiously or as expeditiously as possible. So I just want to try to put some parameters or sideboards to any extension or any vagary with even adjusted as that language choice. I'm done.
Anyone else want to comment? This is a tough one for me, so I'm going to call on myself for a minute. I thought 10-day period was a long time for certainty. I think only extending it creates an uncertainty that I think sends a signal to the industry and would be otherwise unworkable. So I'm just going to try and explain that I'm against the word extending it. I think the better policy would be that it can be 10 days or it can be something shorter than 10 days. Just makes sense to me. Other states have gone 3 days, period. And I can also go with 3 days for a protest, but I don't know that that works for Utah with the uncertainties we have with the additional players in the tribal lands, SITLA, BLM, possibly Forest Service. So in balance, and I say in balance, I'm good with the 10-day period. I may argue for something shorter than that, but I would be fine with saying I think it needs to be black or white. Adjusted doesn't give me the exact meaning, although I think adjusted is much better than waived, because waived doesn't give you a definite end date. Whereas adjusted, it says that you're going to tell them how it's adjusted. So adjusted is a better word for me. Let me think about this some more, and I'm going to call on Gordon Moon. I'm done.
So John Baza could correct me on this, but I mean, APDs now take quite a while. I mean, there's a time period for them to be approved. I understand this 10 days is just to give the public and other non-operators the opportunity to see, you know, what is being applied for by the owner or by the applicant. So I would hesitate to have I guess the one example you gave, Ruland, is something that could happen. But typically, I mean, it's a process for the companies to apply for an APD and then to prepare to drill. So I would almost just recommend taking it out and leaving it at 10 days. But I don't want to, like John was talking about, there are times where an operator doesn't act, and maybe you need to give that additional time to protest. But so anyway, that's my thoughts. Thanks.
Any new thoughts that we haven't discussed so far? Yes, Ms. Davis.
In the meeting I attended in January, which was attended by the Petroleum Association and some other operators, both large and small, the original thought was 30 days, and the 10 days was a compromise, and the waived was put in with the thinking that it could be extended if there was a problem with the current, with the person the operator that applied for the APD. So that is the background that I recall from that January meeting. John, do you recall that differently? You were in that January meeting.
Yes, Ms. Davis, this is John Baza. I recall it the same way you did, that there was great concern about how short we wanted to make the protest period. And I think we made that concession that the protest period could be waived by the division if there was some showing that, for example, the operator didn't follow through on its commitments, or there was some question as far as whether that operator really had the responsibility of operatorship. But maybe to help with the comment that Mr. Moon made, you'll see earlier in that rule, it says that the protest period begins when the division has approved the well and posted it on its website. So yes, there is a lengthy process sometimes in terms of going through the approval. And very often operators are pressuring the division to get its work done so that they can get that approval as soon as possible. So I think all we're talking about in this scenario is how long do you want to give the public or other non-operators or interest owners the ability to say, hey, wait, hit the pause button. There's something amiss here. So, but like Susan, I think we talked about the 10 days as being as short as it was, only because there was a possibility of lengthening that out if there was some good reason to do so.
John, are you done?
Yes, I'm done.
Okay. I would like to suggest two things. Number one, I would like to make one comment, and then I'd like to take a break and let council see if they can contact those that were involved in the compromise. I don't believe anyone understood it, or not, that's not correct. I think there may be some misunderstanding of what I previously said. I know I've been involved in regulatory changes where there has been a compromise. And by making a willy-nilly change on something that had, thinking that it's a 1 on a scale of 1 to 10, when the actual proponents thought it was a 9 or a 10, is really something that we need to make sure we understand. I feel like I'd be making an uninformed decision if we didn't have some feedback on how this fit into the overall negotiations that resulted in a compromise. Board members, staff, what do you think about taking a short break and letting the attorneys have a conference call with whom they can talk to, and then come back and report to us if they can? Can I get a thumbs up from anyone that feels that that might be appropriate? Okay, it looks like that's okay. Mr. Hanson.
I just have one comment. This is Chris Hansen. I wonder if in that conversation that we address what Mr. Begley mentioned about sideboards. Do we propose a not to exceed period of time? You know, that if we were to keep the same language about waived and then said something to the effect of not to exceed 20 days or not to exceed, 30 days, something as an endpoint. Just a thought, and I'm done.
Okay, we're going to take a break.
Wait, just a minute.
I didn't see you there.
Isn't there something earlier in this rule that the time frame cannot be extended if certain things have been met, John? Isn't that in 2?
Hold on a second. Let me pull that back up.
I'm pretty sure there's something that says you cannot contest it if certain things have already happened. I think it
Chairman
was
Gill,
earlier than-
this is Haley Souza.
Okay, Susan, is it okay if Haley responds?
Yes, I'm done.
Okay.
Susan, you are correct. There is language. I believe it's 2.7. Keep going, John. Keep going back. I think it's.
Is it under designation of operator or is it under?
I think it is, but I think it's under one. Where is that language?
Is that where the APD, so it's where the word preparation for drilling is used?
Uh-huh. I think you keep going back.
We're back into the definitions now.
Oh, dang. Where is that?
I don't think it's in.
Chairman Gill, Gordon Rowe here for the division. I believe it's 649-2-4 sub 2.1, which is slide 8.
Okay.
That's correct.
Okay, I'm there now.
Okay.
So whatever decision, sorry, this is Haley Souza. Whatever decision we make and in the language change also needs to be made in this provision. Susan, this provision, we specifically added in the language about the waiver in this provision to make it clear that if an operator has undertaken preparation for drilling, that has already commenced, that the protester can still make a protest within this 10-day period. So that in the event that the operator acts early and undertakes preparation for drilling prior to APD approval or prior to the termination of the 10-day period, that those actions are done at their own risk and will not preclude a protester from having the opportunity to protest.
Yes, that's correct. But it also says, this is Susan Davis, if it has been approved and the protest period has elapsed, Let's see, I'm rereading this because my thought was then they could not challenge it, but I'm not sure that's what this says.
Susan, are you done
I'm done.
for the moment? Okay, Mr. Brown.
Yes.
This is Mike Brown. That was the point I was going to make. I believe 2.1 actually states that the challenge can't be made if it's inclusive. The protest period has to be exceeded. The division has to have determined that a 10-day period with extension or waive was warranted, and that no challenge was made to the APD. So I don't think there's a conflict. I think it's consistent. I yield back.
Okay. All right. We're going to take a break and ask our council to make that conference call if you can. And we'll check back in 15 minutes to see if you found what we need to find. If not, we'll extend the break for another 15 minutes because we want to get it right. My understanding going forward is that we are basically okay, except for section 4 and this 2.1, and that there isn't any outstanding other issues. But this is a really good one. I think that Susan has caught it well. I think there is a policy statement there that we need to make sure we understand. And so can we take a 15-minute break? Let's just order it. We're in a 15-minute break, and we'll come back and check in 15 minutes. Thank you.
Merlin, the meeting is live.
Welcome back. We are back on the record and we are no longer on a break. I would like to call on Mike Begley to give us an overview and Haley Souza to give us the details. Would that work? Okay. Quick check of, do we have the board members here? I can see all but one. Mr. Moon, are you on the, yep, okay, we have the full board back. So we'll start with you, Mr. Begley.
Thank you, Chairman Gill. Are you picking me up okay from the break?
Yes.
Per the board's request, the attorneys that are involved in this rulemaking matter were able to participate in a conference call to discuss if there's a way forward with respect to what appears to be unintentional but a certain ambiguity within the rule dealing with what kind of 10-day notice for a protest period when APD is issued, and the discussion, the only point of discussion that hasn't been really agreed to with respect to revisions is whether or not there should be a waiver period that's either shorter or longer as contemplated by the rule presently as drafted. In following up with Chairman Gill's directive that the attorneys actually try to understand the drafter of the current set of rules, get a full understanding of what was intended by those rules, and encapsulate how those rules were developed so that we can actually inform the board with all available information under the current circumstance, which is fairly challenging since we cannot be communicating with the public in real time. We were able to proceed in a number of different ways with the challenge, and that perhaps maybe we could come up with some sort of draft rule that would be workable under the current situation, but with a real extensive and clear caveat that the proposal that's before the board now is also going to be subject to further approval and vetting by the attorneys for UPA and Mr. Hunter and their clients, and their approval of, they haven't had the opportunity to see what this revised rule looks like or approve it, but they are both prepared to at least submit this as a compromise at this juncture with that caveat that it does require client approval going forward. And to that and background, I leave that to Haley Sosa, counsel for the division, who's hopefully had the time and opportunity to review the rules with those other attorneys online. I am done.
Are you done, Mr. Begley? Okay, Haley?
Thank you. This is Haley Souza. Director Baza, are you online, and could I trouble you to put the language back up on the PowerPoint?
Yes, hold on just a second. Just tell me which page you want to go to.
Let's start with 649-2-1 part 2. So it looks like you have to go backwards.
Two -4 part 2.
No.
No.
This says 2-1. That can't be right though. It's about the language that we were looking at second that Susan had brought up. Oh. We can talk about this first. That's fine. So, again, once more wanting to reiterate the caveat that this has not been vetted by the clientele of Mr. McDonald or Mr. Hunter, but that those attorneys will be taking this to their clients The proposal is that beginning on, so you see the highlighted language, go above that to the next sentence where it begins, any operations commenced. Are you guys with me? So any operations commenced after the APD approval, but before the 10-day period has expired, will not constitute a violation of the APD, but will be at the operator's sole risk, period. The remainder of that sentence will be struck. So to be clear, the language and shall not be deemed preparation for drilling for purposes of Rule 649-242A will be struck. The language, the highlighted language will also be struck. So the sentence, any operations commenced will end after operator's sole risk, and then the next sentence is the basis for the protest. Oh no, that doesn't work either. Oh geez, I'm sorry, you guys. I had been through this. We need to strike that language as well about the basis for the protest. It would just be the APD approval shall be stayed. Oh, that doesn't work either. I'm sorry, you guys, and I'm sorry to all members of the board. I thought we had read this carefully, and I'm seeing that we have not. Chairman Gill, do you support a 5-minute recess for me to have additional conversations with Mr. McDonald and Mr. Hunter?
Any problems with that, board members? Let's take a 5-minute break. We're back from our break. This is the Utah Board of Oil, Gas, and Mining. At the last time we left, we had both Mike Begley and Haley Souza as counsel. Which one of you would like to go first? Just hold up a finger. Okay, Haley, we'll have you go first. Please proceed.
Thank you, Chairman Gill. Haley Souza, my sincerest apologies for this confusion. I'm confident that we have it right this time. So, Director Baza, can I entice you to put that language back up on the screen?
Okay.
Perfect, thank you. So I would like to ask everyone to please bear with me. Read along with me. I'm going to just read how the language of the rule will be, and then kind of explain afterwards what we did. All we've done is delete language and move language around, with one exception, and I will talk about that one exception at the end of my final reading. So, Rule 649-3-4, Part 4. A non-applicant owner within the drilling unit, or in the absence of a board order establishing a drilling unit, in the leases covering and any unleased oil and gas in the lands upon which the well is to be located, may then protest the APD approval by filing a request for agency action with the board within 10 calendar days of the posting of the APD approval by the division on its website in accordance with Rule 649-243. The basis for the protest may be, but is not limited to, challenging the operator's controlling working interest in the drilling unit, the operator's ability to timely, efficiently, and economically develop the drilling unit, or the non-applicant owner desiring to drill an alternate well for just cause. The APD approval shall be held in abeyance pending resolution by the board of the request for agency action. Any operations commenced after the APD approval but before the 10-day period has expired will not constitute a violation of the APD, but will be at the operator's sole risk, period. So what we've done is, if you look at this slide, the highlighted portion has been deleted together with everything before that up to the comma after APD. So 2 lines above that, it starts with a violation of the APD, comma, everything after the comma has been stricken. No, I take that back. After sole risk. So a violation of the APD, but will be at the operator's sole risk, period. So, and shall be deemed preparation for drilling for purposes of subsection 649-242-1 has been stricken. The 10-day period may be waived by the division in its sole discretion upon written application and good cause shown has been stricken. And this language, beginning with the basis for the protest, has been moved up so that the paragraph reads more chronologically to keep the basis for the protest together with the protest. So the one change that we've made is, if you look on the slide, the last sentence that's on the slide that says the APD approval shall be stayed pending resolution by the board, we have changed the word stayed to held in abeyance. That language is consistent with other rules in the other oil and gas rules that use that identical language. So please, board members, do you have questions?
Okay, board members, do you feel like you understand that? Is there a chance to get the revised language on the screen? Natasha, is that something you could do very quickly? Or is it something
Natasha,
that...
I'll send it to you really quick.
I would need the sentence read back out. I tried to keep up with it, but I didn't
Okay.
didn't quite do it. So if you read the sentence again and I hurried and typed it out, I could throw something up.
No, Natasha, let me just send it to you.
Oh, okay. That that works.
I'm typing on the wrong keyboard. Sent.
Okay, Mr. Begley, while they're doing that, would you like to speak?
Thank you, Chairman Gill. Haley, just for the record, could you please articulate the process and who you were on the phone with and how that process was involved in terms of creating that new rule, please?
Absolutely. So I spoke with Fred McDonald's, who is counsel for UPA, and with Tony Hunter, who is counsel for his clients. I'm not sure who those clients are. My apologies, Mr. Hunter. And there really was a misunderstanding on my part as I first read this language and it went back into the protest language. It didn't connect in my head that just belonged farther up. And so as I was speaking on the phone with Mr. McDonald and Mr. Hunter, it became clear that for flow, the rule would be more clear and would make more sense if that language were just moved up, not changing the language, just making it such that it was in closer proximity to the protest language above.
All right. How should we proceed, staff? Can we get the language so there's not a debate or a question about it? Mr. Bozza, do you have any advice?
I think we're just waiting for Natasha to type up or present what Haley is.
Okay.
Sent to her.
Sorry, if you give me one moment, I can get it pulled up.
I wonder if it might also make sense to go back and look at the language that was on slide 8, because that language will also be changing while Natasha works on that in the background.
Okay, Haley, I found the area that you wanted to talk about before, so let me get to it.
There it is. So in 2.1, this also references the waiting period. So this would be revised to state, no challenge may be made once the APD for the well has been approved, comma, and the protest period specified in R 649-3-4 Part 4 has elapsed, period. That will be the entire language of 2.1.
Sorry, say that again. So you would just put a period after elapsed and delete the rest?
Correct. But you would also need to add a comma after approved and an and.
Okay. I'll just make that note.
So is the protest period open-ended? This is Susan Davis.
The protest period is not open-ended. It is now 10 days and 10 days only. So we won't have a longer 10-day period, but on the other side of that token, we will not have a shorter protest period either. So
you've just taken 10 days out of 649-2-4 and out of 4. Where is the 10 days?
The 10-day period is still the 10 days doesn't go anywhere. It's the waiver of the 10 days that's going away. So in making this change, we're still allowing for a 10-day protest period. We're just removing the language of the waiver because that's causing ambiguity that will inevitably come back to us.
What I'm asking is where the 10 days is in the rule. I do not know.
So the 10 days remains in, John, can you go back?
Yes,
The
would
the
you,
protest period, the protest
you
period
please-
remains.
let's go to that 2.1 where you just were.
Yes. So
Let's
Susan,
go to that one. Okay. Now, will you read that again while Natasha's typing and she can double check it? So read that again after the change.
no challenge may be made once the APD for the well has been approved and the protest period specified in 649 3-4 part 4 has elapsed. Period.
Okay, now go to 4. And make sure that cross-reference is the same. So we are 649-3-4, part 4. So the cross-reference is correct.
So
And then
Susan, you can see in here the 10 calendar days for protest remains. So after an APD is approved, then the 10-day period begins, and at any time during that point, a protest can be made.
Thank
Natasha,
you.
are you with the new language?
Yeah. So I can.
So I will stop sharing and let you throw up the new language.
All right, I have it sharing. Can you guys see it?
yes.
Okay. It doesn't show up on my end, so I just wanted to make sure.
So Natasha. Oh no, you're right.
Natasha, we're having issues on the broadcast. Could you place PowerPoint and slide view?
Yeah.
Natasha, this is John. Are you able to see your own slide?
No, it's pulling up on my computer and I can't see anything else.
Natasha, we're able to capture that at the moment. If you wish to proceed, we're good for the broadcast.
Okay. Yeah, whatever I need to do to make it better to view.
Chairman Gill, this is Haley Souza.
Proceed.
Do the board members have additional questions on this slide?
Yeah, we're going to discuss it, I think, once we have it in front of us. But I would need to verify that that you agree with the language that we are seeing.
I do. And I'm done.
Okay, board members, Mr. Baza, do you see that? And is it, let's start with the division. Is that?
Yes, this is John Baza. I'm reading the language. And as far as I can tell, it is the language that Ms. Sosa presented and modified for this part 4.
Would it be okay if I told you how I read it? What I'm seeing is that there's 2 concepts that are being taken out. the waiver of the 10-day period and the preparation for drilling is also taken out, that it's not applicable for purposes of 649-2-4 sub 2.1. Is there any questions of the board about that revised language? Okay, let's start with Mr. Church. You have the mic. Mr. Church, we can't see you or hear you.
There, have you got me on now?
Okay, there you are.
Yes. In the first sentence, where it talks about a non-applicant owner within the drilling unit or in the absence of a board order establishing the drilling unit in the leases covering, I don't understand if there's a word left out in the leases covering and any unleased oil and gas in the lands upon which the well is to be located.
Okay.
Is that a high, I don't understand if there's a comma after covering, or whether there should be one.
Let's take a quick look at that.
Is there a parenthetical phrase right after covering?
Or in the absence of a board order establishing a drilling unit, in the leases covering any unleased oil and gas in the lands upon which the wells be located.
Yeah, I don't see that on.
I don't, isn't that contradictory? In the leases covering any unleased oil and gas in the lands? How can it be unleased and still have ownership in the leases?
Mr. Gill, can I add some clarification?
Yes, please.
The language that we're trying to reach for
Yeah,
here.
I'm through. I just don't understand that phraseology there.
Okay, Ms. Church, is it okay if John Baza talks?
Yes.
And then we'll come back to you.
Natasha, I am going to share my screen if possible. Can you take this one down? So this is the old language, obviously, but to address Mr. Church's question, if you look at the first part of the designation of operator rule, we're using some of the same language. For example, in this 1.1, at the end, it says more than 50% of the working interest attributable to the leases covering and any unleased oil and gas in the lands upon which the well is to be located. The reason it says that, and someone will have to correct me if I'm wrong, is we're trying to identify both the leases and then the unleased portion that isn't dedicated to a lease. So it's trying to cover both cases or scenarios where you have working interest in a lease or you have unleased working interest. And it's similarly stated in the second part of that section, and I believe in the third part as well. So I think what they've done is try to capture that language and bring it over to part 4. I'm done.
Okay, we're back to you, Mr. Church.
Something's wrong with my reception. I didn't hear any verbal comments by Mr. Baza. I guess I'm having some technical problems here.
Can you hear me?
Yes, I can hear you, Chairman Gill.
John, do you want to repeat that so that there's no confusion? Can you do a sound check so that, see if Mr. Church can hear you?
Testing, testing. This is John Baza.
Mr. Church, did you just hear that?
I did not hear that.
Okay, we got a technical issue here. We've got John Baza presenting. John, let's do another check.
Check, check. John Baza. 1, 2, 3, 4.
Is there anyone that did not hear that? Mr. Church, did you hear that?
I still did not hear it. It must be
Okay.
on my.
Jump off and sign back on.
Chairman Gill,
Yes.
we're noticing some technical issues. If we could ask for a minute pause and have Mr. Church exit the meeting and return, we believe that will help flush what's going wrong inside the video conference.
Okay, thank you.
Okay.
We'll just have a short technical break. Again.
Mr. Church, can you hear me now?
Yes, I hear you now.
Okay. Let me go back to the screen that I was presenting and repeat what I said. If you go back to the beginning of the designation of operator rule and subparts 1.1, 1.2, 1.3, the same language is being used as what is being referred to in part 4. It is that, for example, at the end of paragraph 1.1, says more than 50% of the working interest attributable to the leases covering and any unleased oil and gas in the lands upon which the well is to be located. That language is consistent in part 1.2 and part 1.3. And I believe the reason it is there is that we're trying to show working interest in leased portions and unleased portions where the well path will go on a horizontal well. And again, I'll flip over to the next screen. The same language exists for working interest attributable to the leases covering and any unleased oil and gas, and the same for part 1.3. So if I go all the way back, well, I guess the new language is what Natasha has on the screen. So I will stop sharing and have Natasha throw that slide back up.
Natasha, are you ready? Thank you.
So on Natasha's screen, it shows in the leases covering and any unleased oil and gas in the lands upon which the well is to be located. And this is
I
a
am not
non-
seeing anything.
You're not seeing.
I am not seeing anything, Natasha. I'm not seeing the presentation from Natasha, nor did I see John Baza's presentation.
Oh dear. Technical team, are you aware of this problem?
Stand by one moment. Susan, I will give you a call via cell phone.
Thank you.
Okay, we are at a 1-minute technical break. on very well may have solved the technical problem. We'll soon find out.
John, this is Bob.
Chairman
I've been
Gill.
able to see slides throughout.
Okay, let's
Chairman
go.
Gill, I can see the slides again.
Okay, I'm going to say you're done. And who else was speaking just now?
I think that was Bart.
That was Bart Kettle, Deputy Director. I was just commenting that I've been able to see the slides throughout.
Okay. So I think the technical glitch is currently fixed. So John, what you were beginning to talk about is on how the language of 1.1, 1.2, of 1.3 of how an operator is designated then should flow over and coordinate with number 4.
And I think
back to you, Mr. Baza.
And I think we're talking about specifically the phrase in the leases covering and any unleased oil and gas in the lands upon which the well is to be located. So again, to address the concern Mr. Church has, it is consistent language and it's just saying that we're trying to address both the leased portion of the well path or the unleased portion where an owner has interest. And I don't believe that there's any comma needed. The only thing I see different in part 4 is the reference to working interest in the leases. So again, I don't know that I have the expertise, not being a landman, to say whether that's important or not, but the phrase that Mr. Church was worried about is consistent.
Thank you. I can see that now. It's clarified for me.
So let's take that parenthetical phrase out. Let's see if this makes sense. So we start with the number 4. A non-applicant owner within the drilling unit in the leases covering and any unleased oil and gas in the lands upon which the well is located may then protest. Is that a fair understanding? Okay, we're going to take a break. I think we have enough people confused. But the question okay, whoever just did that on the screen, does this sentence make sense to everyone? A non-applicant owner within the drilling unit or in the leases covering any oil and gas, I'm saying this, in the leases covering and any unleased oil and gas in the lands upon which the well is to be located. Is there a better way to say that? Gordon, you've been quiet. Jump on that.
I was just going to comment in general. I'm in approval of all the changes made. I agree with Steve that having in the leases covering and, I mean, you can, if you read it the right way, it makes sense. But if you run into that and quick enough, it just throws you off. So I'll have somebody better at English fix that, but probably fix that little piece.
Okay, what if you put, I'm not proposing this, but just to understand it. If you put after a non-applicant owner, number 1, parentheses, 1, parentheses, and then go to the next where the language restarts and put in 2, put in number 2. And then after the word and on that same line, and then, so if you, okay, let's say a non-applicant owner, parentheses, or colon, pardon me, colon. And then where it says upon which the well is located, right there upon, put a return. It shouldn't be, so it read the non-applicant owner in one of these three circumstances upon which the well is located. Is that a fair reading of what you intend, Mr. Baza?
Non-applicant owner.
I hope I'm not making this more confusing than it needs to be.
Yeah, unfortunately, I'm,
Put the number 3 before the and. And then in the lands, put that down in the next line. Does that explain it?
This is Rich. Rich Borden. I have to say, I have trouble understanding what this is trying to communicate to me.
And yeah, I believe we're confused as a board, and I don't know if a break is the best way and let the attorneys take another 15 minutes. Do you have that kind of time?
Mr. Gill, one more point that I need to make, if I could.
Go ahead, Mr. Victor.
Well, and this is to Natasha. If we look at the information after the strikeout, where it says the basis for the protest may be to challenge the operators controlling working interest in the drilling unit, I'm a little concerned that we've missed some language in the next phrase, because it's not making sense to me. The operators or the non-applicant owner desiring to drill an alternate well for just cause. Did we miss some language that came across from Haley there? Could you double check that?
Yeah.
That break?
Yeah, let me double check that right now.
In any case.
It was not my,
Sorry.
I can see a fix, but I think it might be more confusing trying to understand what the fix is until it's done.
I guess what I would ask Natasha to do is maybe if she could get offline with Haley and make sure she's using the correct language that Haley provided to her.
Okay.
I'm checking the email that Haley just sent me. So if you give me just a moment, I'll make sure I have it correct.
Well,
Chairman Gill, did you? Chairman Gill, did you intend to strike out that parenthetical?
No, it was just for clarity. So what I thought we'd do, let me try a number. When Natasha's ready, let me try a different tact. There's really two concepts. And I think I can show you how it works. And I think we can fix this, but it might be confusing just to go through it. So if you'll just bear with me. Okay, Natasha, you tell me when you're ready.
Chairman Gill, Mike Brown, can I ask a question?
Sure, go ahead. You have the mic.
We've messed with this enough. Are we going to have to take this back to UPA and Mr. Hunter again now to make sure they're not going to have issues with this language?
We might, but may I suggest, if you're done, let's try one more attempt.
Yes,
Would
I
that be
yield
okay?
back.
Okay. Natasha, when you're ready.
Okay, I should be good. I just missed that one sentence, but it looks like everything else is the same as what Haley sent me.
Okay, let me see if this makes it. So on the first line, number 1, within the drilling unit, or number 2, put a 2 there and cancel the cross out. So bring it back in. And then where the number 2 is, put that as 2A. And put the number 3 as 2B. And see if this is what was really intended. A non-applicant owner within the drilling unit, or in the absence of an order establishing a drilling unit, in the leases covering and any unleased oil and gas leases. And then that's where the word is. That's what we need, is some word that goes right in there. And you could solve it by saying within the drilling unit in the lands upon the well, which is the wells located, or in the absence of a board order establishing drilling, and in the leases and any unleased oil and gases in the lands upon which the well is to be located. It's redundant, but that makes sense to me. And Natasha, I don't know how you can put a carriage return in there with and make that all look like it should. So take the words "in the lands upon which the well is located" and copy that and put it right before the "or" number 2.
Before?
Before the "or."
Oh, right. So right there.
So it says, a non-applicant owner within the drilling unit in the lands upon which the well is located, or 2, in the absence of a board order establishing a drilling unit, in the leases covering and any unleased oil and gas leases in the lands upon which the well is located. Is that understandable? Or do we still have an abundance of confusion?
Mr. Gill, this is John Baza. I believe that this is what was intended, is that we describe a case of drilling unit or no drilling unit. And then in the case of no drilling unit, there's leases and unleased portions.
Okay, and if that is true, then take out the 2A and 2B. And you have something that makes sense now. So let's try it again to see if anyone's still with me. A non-applicant owner, number 1, within the drilling unit in the lands upon which the well is located, or 2, in the absence of a board order establishing a drilling unit, in the leases covering and any unleased oil and gas in the lands upon which the well is located. So let's take that 5 out, Natasha, and just continue that. The number 5, okay. And then after where it says located, then put a carriage return before may then protest. Does that make sense? So 1 and 2, if you satisfy number 1 or you satisfy number 2, then you can protest the approval of filing. So it's really the procedural. Hey, now anyone want to comment on that?
Chairman Gill, may I comment? This is Richard Borden.
Please do.
In your old 2A, in the lease is covering what? Doesn't there need something to, what is it covering what?
I think if you took the word covering out, let's see how that reads. In the absence of a board order establishing a drilling unit in the leases and any unleased oil and gas in the lands upon which the well is located. And if there's a chance that does make sense, let's take a short break and have the lawyers talk with the outside attorneys and see if they occur that's what they meant with this language. And I'm sorry to drag this on, but I would like to have your indulgence so that if there is a chance we can have this voted on today, that we take that chance. Hey, Mr. Hanson.
Just as a point of clarification for me, wasn't Mr. Boz's earlier conversation that we had when Mr. Church asked this question, wasn't Mr. Boz's conversation describing what the phrase in the leases or the leases covering? Wasn't that your attempt, Mr. Boza, to clarify what that means?
Mr. Hanson, what I was trying to point out is that it is language consistent in the previous parts of these rules that we talked about earlier today.
Right. So
the actual phrase, frankly, came from discussions with the Utah Petroleum Association, and it had to do with some clarity that the division wanted to say, well, which interests are you referring to? Which oil and gas interests are you referring to? And I think they came up with the language of saying, well, it's the leases covering and any unleased oil and gas in the lands upon which the well is to be located. So I think once we get this cleared up, we probably have to be consistent with where else we've used that same phrase in the previous parts of the rules.
right, leases covering appears in several places.
Right.
Okay.
Okay, so attorneys, can I give you the job of doing this? Take the language out of 1.1, 1.2, and 1.3 and interject it into this, or go with this language, but will you please check it with counsel? And we'll take a 15-minute break. Would you respond to that idea? And I know everybody's has a frustration level that we're getting very close to tipping over. Would you bear with us on this for just a minute, Mr. Begley?
Yeah, thank you, Chairman Gill. I just want to be clear what you're asking again. Could you summarize it?
Okay, let's go back to 1.1 or 1.2 at the very beginning.
Okay, Natasha, you're going to have to so let's just look at 1.3, and hopefully you can see my cursor too. You can see that it says blah, blah, blah of the owners in the drilling unit or in the absence of a board order establishing a drilling unit in the leases covering and any unleased oil and gas in the lands upon which the well is to be located.
Okay, so what we're really just taking is where it says more than 50% of, if, what's the word at the non-something owners, and then you just track that language, it should be about the same. The non-APD people, what was that? Can we go back to 4 again? The non-applicant owner. Okay, if a non-applicant, or we don't have to have if, a non-applicant owner within, and then if that word is the same as the rest, why do we need to worry about it? Let's just go back and use the same language that's used, so it's being used 4 different times the same way. Are we clear on that? Is that Mr. Begley?
Thank you, Chairman Gill. My interpretation and readability issue, and obviously I was not involved in any part of this, but it still remains in the lease is covering what? That language there, it needs to have a clarification point or phrase to it. And I'm gonna.
Can Natasha offer something?
Mr. Begley still has the mic. Let's let him finish and then we'll go to you.
I'm done. I turn it over to Natasha. That's just
okay.
The readability that I have is in the lease covering and as to what.
Okay, Natasha.
I feel like it could be solved with a couple of commas if you do lease, because isn't it lease covering the lands upon which the well is to be located?
Well, let's take a break and have you and Mike and Haley work on the language and come back with a proposal, because I'm getting the sense that the board members' frustration level is way high. Would you be willing to do that?
Yeah.
And if you can convince them, then I think you can convince us. Haley and Mike, is that acceptable? And Mr. Baza, is that acceptable?
Yes, that's fine. Perhaps I could get on that call as well, Natasha.
Okay. Why don't you guys take a minute and see if we can't broker some language that makes sense. And so we're in a break. Let's take 10 minutes and see if they can't do it. Let's take 15 minutes. Is that okay? I know we're over 5 o'clock, but let's see if we can get there.
So we're
Chairman
off the
Gill,
record.
we will
We're off
start.
the record.
We will start a
Yeah.
15-minute break.
Okay, let's do that.
1.
Okay, we're back on the record. If I'm reading body language correctly, we still have a problem, and we gave it a college try. We valiantly tried to do it. What we're trying to say is that a non-applicant owner can protest, whether they're in a drilling unit established by the board, or if they're not in a drilling unit established by the board, they are on the lease where the well's drilled, or on the unleased land where the well's drilled. But having said that, I don't think we're going to get there tonight. And I think there's a level of confusion that I would like to recommend that we continue this matter until next month. Unless someone can see a path forward, I think the level of confusion is high enough. And even if we came up with language to get everyone to understand it, would get us to the point where I'm not sure we're making an informed decision. I'd welcome any feedback on that recommendation.
I move we continue this matter to next month, to the May meeting.
Is there a second to that?
I second.
Okay. Is there a discussion of that motion? Seeing none, we'll take a roll call vote. We just lost Julianne. We'll bring her back. Julianne, will you do a roll call vote?
Yes, Mr. Chairman. Mr. Richard Gordon, how do you vote?
Yay.
Mr. Michael Brown, how do you vote?
Yes.
Mr. Stephen Church, how do you vote?
Yay.
Excuse me, Ms. Susan Davis, how do you vote? Yay or nay?
Yay.
Mr. Ruland Gill, Chairman, how do you vote?
Yay.
Mr. Chris Hansen, Vice Chairman, how do you vote?
Yay.
Mr. Gordon Moon, how do you vote?
Yes.
Mr. Chairman, I have 7 affirmative votes.
Thank you. Is there any other matters then to come before the board? Yes, we'll turn to Haley Souza.
Thank you, Chairman Gill. I just wanted to, Director Bozza, are you still there?
Yes, I am.
Will you please provide a very brief update on the horizontal well rules?
Yes, Mr. Chairman and members of the board, we have been working on the horizontal rules in parallel with the operatorship rules. We didn't get as far along in terms of our dialogue with the various stakeholders as the operatorship. It was our intention to be able to bring horizontal rules to next month and have the same conversation we had today. I would state to you that the horizontal rules, frankly, should not be as demanding as the operatorship, that horizontal rules were more mechanical in nature. And we had we've had some feedback between us and the UPA. We had an internal meeting with division staff on Monday of this week. So we think we can press forward and likely have those at a state where we could discuss those with you next month as well. And that's my report.
Okay, you done?
Yes.
Okay, board members, to drag this on for just a couple of minutes, I want to make sure that I'm clear on something, and I'm going to try and do just a straw poll. If you took where we are today and took, like, we're going to bifurcate it, just the issues we've been on for the last 3 hours dealing with that subsection 4 and the correlation between that and the previous provisions, and said, okay, that's still on the table. We haven't settled it. We're continuing it next month. Board members, can I move forward with the idea that on the remainder of it, are we close to an agreement, or would we have any outlying concerns with the board unless there's some sort of a correlation involved? I'd like to take a straw poll. Julianne? So the question before you is the rest of the proposed rule okay with you? In terms of, or do we still have something to work on those? Julianne, will you take the straw poll?
Yes, Mr. Chairman. Mr. Richard Borden, how do you vote?
I
Yay or
feel,
nay?
oh, I think it's more nuanced than that, isn't it? I feel like we are close to agreement, and we were mostly bogged down on semantics and making a clear sentence in the last 2 hours, which shows you the limits of the technology and perhaps our fatigue.
We'll take that as a yay.
Yay.
Okay.
Thank you. Mr. Michael Brown, how do you vote?
Yay.
Mr. Stephen Church, how do you vote?
Yes.
Ms. Susan Davis, how do you vote?
Yes.
Mr. Ruland Gill, Chairman, how do you vote?
Yes.
Mr. Chris Hansen, Vice Chairman, how do you vote?
Emphatically, yes.
Mr. Gordon Moon, how do you vote?
Yeah.
Okay, then, thank you very much. I think we're going to forego the quality, the continuous improvement discussion after we adjourn. So I think the only thing left is a motion to adjourn. If anyone will make that, I'll make that. Julianne, will you do a roll call vote? The motion before you is to adjourn.
Mr. Richard Borden, how do you vote? Yay or nay?
Yay.
Mr. Michael Brown, how do you vote? Yay or nay?
Yes.
Mr. Stephen Church, how do you vote?
Yay.
Ms. Susan Davis, how do you vote? Yay or nay?
Yay.
Mr. Ruland Gill, Chairman, how do you vote?
Yay.
Mr. Chris Hansen, Vice Chairman, how do you vote?
Yay.
Mr. Gordon Moon, how do you vote?
Thank you all.
I have 7 affirmative votes.
Thank you very much. That closes the record on this. Thank you, Michelle, for staying late to our court report. Thank you all. This has been a challenge. I think it has worked up until we got to semantics, and then the semantics didn't work, and we need to figure out how to solve that. So with that, please stay safe, and most of all, please stay healthy. This is scary times. It looks like we're probably going to have at least 1 more month, maybe 2, maybe through the end of the year. We don't know. So bear with us as we work towards this. And the next time we meet, if there is any improvements to the ground rules, those would be welcome. And so with that, good night. We wish you the very best.
Thanks, and same to you, Mr. Chairman.
Technical team, you can now end the broadcast.